25. It is tagged with another case. That is not. I want to withdraw only this one, 25.
25 my lord, already 30 submitted in both cases, 25 and 26.
However, I will submit my submission at that time, 20, when it will call. But right now,
Following-
I want to withdraw this.
You want to withdraw 25
Yes, yes.
and you do not want to
Do not want.
Huh?
Oh, yes.
26, but both the matters will be disposed of.
No, Lordship, I have to submit something. Before that, at this mention, I want to withdraw this only, 25.
Let they both 25 and 26 come then.
Yes.
We'll see to it. Why be in a hurry?
All right.
Because both the matters are in same footing or the
Well,
the
Lordship, yes, yes, Lordship, there is a problem, Lordship, because in that case, 26, 20, yes, 26, it is AB, I am on interim, and it is sessions tribe. If Lordship's record is not called, Lordship, they cannot appear before the trial.
When we matter will be called.
Yes.
Yeah, please, Your Lordship. I beg to differ item number 32, my lord. I have some difficulties today, my lord. Any date, my lord? In the month of May.
Request made by Mr. H. already done for the petition matter is already submitted by Mr. CDA. Ready to see? Yes, you're going to retain the case diary or return it back?
Next week, well, on 7th of 7th or
I don't know,
I don't know, it will be possible or not. 6th of May. 6th of May will do?
My lord.
Or you
It's
don't
too early, my lord. Can be on 13, my lord. The 13 kilo, 13 or 14, my lord.
In that case, it has to be returned back.
It will come update only, my lord, then.
Okay, then it will be 2021. Let it be on 20 or 21st city be returned. Let the matter be accordingly listed on 21, 5, so and so, city be returned according.
There is a
Only
interim
can
order.
update. Interim be continued till next.
May I appear?
Yes,
I'd like to mention here item number 7 of today's list, Lordship. In this connection, I have filed one additional affidavit that may kindly be called for,
We
Lordship.
have already filed.
Lordship. And another prayer, Lordship, regarding item number 29. Public case diary not received in this case. 29.
29 CD not.
He is on interim, Lordship.
CD not received, issue reminder. Yes, what happened when it can be?
CD on my lord, 19th of May.
19th of
Public.
interim be continued till next.
Great pleasure, Lord. Lordship, item number 20, it has been wrongly listed. It's a part hard matter, my lord.
20.
20, my lord.
It's wrongly listed here.
Wrongly listed, my lord.
It was heard by the other bench.
Other bench. Honorable Justice P.J. Soikia's bench, my lord.
You're for the petitioner?
Petitioner.
A good name?
And Bormon, my lord.
20 heard Mr. N. Borman and counsel the petition submitted that the matter is wrongly listed for this bench before this court as it has already been as the matter is in but can you tell us whether it is part heard?
Yes, yes, my lord. I'm having the order, my lord.
Part heard is
Part hard matter, my lord.
is already heard by partly heard by the other coordinate bench officer. In view of this, the registry is accordingly directed to this matter India before that. Any date you want?
No, my lord.
After 1 week as well.
Obliged, my lord.
May it please your lordship. Lordship, I beg to mention item number 46, lordship. Lordship, my senior Mr. M.K. Das is out of session. So lordship, if possible, can it be come up on tomorrow, lordship?
No, not at all.
Then lordship, next Tuesday, lordship, Tuesday or Wednesday, lordship,
6.
because he is
Six,
behind our since
request made by
for more
counsel
than
for the
long,
petition
1 year.
matter is adjourned. Yes, can. 6th of May.
Lordship, deeply appraised.
May I please, your lordship? Lordship, I beg to mention item number 16, lordship.
Item number
16.
16.
Lordship, with the consent of the other side, my lord, this matter may be adjourned for detail, lord.
You are for the,
And for the petitioner, lordship, B. Borgunhai.
have you taken consent of the other side?
Lordship. Taken the consent of
Consent
respondent
of
number
the
2,
other
amicus.
side. Mr. Gauhati, done it. for the petition, paid for an edge of prayer allowed. Estimate record. You want any fixed date here?
Lordship, it can be on 11th of May,
Can it be
11th.
18th of May?
Can,
1/8.
please can be on 11, because there is
11 may not be possible.
on 12th, better.
Are you-
Before 18. Possible.
Yes,
Mr. Lordship, I beg to mention item number 47.
47.
Yes, Lordship, TCR was called for and till receipt of the TCR, the instant case was stayed by this honorable court, Lordship. And today the TCR is not received.
Yes, this year, whether we have received it this year in 42nd,
They are not.
not received. Hard MS Albonic, the learned counsel for the petition. As per the office, this year is not yet received. And it is submitted by MS Bonic that this year will be required for this purpose. In view of this, let the matter be accordingly listed. From the public. 20205. Interim be continued till next set of listing. Raised table in it in calling question.
May it please your lordship. With the consent of the other side, I beg to mention item number 17, lordship. Lordship, my senior Mr. A. Bhattacharya is having some personal difficulty, due to which I am praying for adjournment in this matter.
17.
Yes, your lordship.
You have taken consent of the other side because
Yes,
there
Your
are
Lord.
many councils' name has been reflected. You have
Uh,
taken consent?
Yes, we have taken consent from the other side.
You are Mr.
As Basak.
S. Basak. Part Mr. S. Basak appearing on behalf of Mr. A. Bhattacharya for the petition and with the consent of the other side, paid for an adjournment, stating that and his counsel, Mr. Bhattacharya, has some personal inconvenience. Prayer allowed is the matter according to 18th of May.
Lordship can be fixed on 5th of May.
5th? No, sorry. 18th of
Then your lordship, may it be fixed at the end of May month.
at the end of May. 29th of
Much obliged. Lordship, there was also an interim order.
29th of May, corridor. Interim be continued till next day.
Much obliged.
May I please, your lordship. I beg to mention item number 15, lordship.
1/5.
1/5. I am for the petitioner, lordship. Respondent counsel just telephonic instructed me to adjourn the matter as they, due to waterlogging, they could not come today, lordship.
Otherwise, you are for the petition.
I am for the petitioner, lordship. They have informed me to take adjournment. Due to waterlogging, they could not come, lordship, for this.
At the request made by learned counsel for the respondent, Mr. A.B.T. Hawk, counsel for the petition, paid for an adjournment, stating that due to waterlogging, the counsel for the respondent could not appear at prayer and
Interim may be continued.
1/3. 1/3.
Interim may be continued.
Interim be continued till next.
Obliged.
Lordship, I beg to mention item number 27. TCR
27.
was called in this matter, but the TCR has not been received.
Your lordship, I am for the informant, your lordship. I filed my Bakalanama yesterday. Your a copy
You
of
are
the
saying for 27.
Yes, your lordship.
27. It's a
20.
bail matter.
Yes, your lordship.
I'm appearing for the informant, your lordship.
You have already filed your Bakal.
Yes, yesterday I filed my Bakalanama. A copy of the bail application may be furnished to us, your lordship.
And whether this year we have received or not. We have a
27.
note 9.
Bakali file.
Part Mr. A. Mishra, the learned counsel for the petition. And also part Mr. B. Bot, the learned additionally. From the office note, it reveals that this year is not yet received. Issue remain raised tribal routine. Pardon, Mr.
J. Das.
J. Das, had already entered into evidence body in profit and filed his wakalat. It is submitted that a copy of the bail petition will be provided to the respondent, informant respondent. In view of this, the petitioner is hereby directed to provide a copy of the petition during the course. List the matter accordingly. Holding.
Can it be on 13th, your lordship?
13th. 1-3. Okay, 32.
Obliged.
Deeply obliged.
May it please your lordship. Lordship, 483 bail application. FIR is at page number 9. Your lordship. May I read the FIR? Your lordship?
Yes.
FIR, your lordship, page number 9. Sir, with due respect, I would like to state that on the night at about 2 a.m., the opposite party set fire to my house. This incident has arisen due to a long-standing quarrel between my sister's husband and the accused because of an extramarital affair involving the accused's wife. In a fit of aggression, the accused committed the act of arson, resulting in the destruction of Gautam Ghosh's shop by fire. With the help of local villagers, I managed to extinguish the fire. However, property damage amounting approximately rupees 20,000 was caused. My father witnessed the accused fleeing the scene after the fire was set. Therefore, I request you to take kindly appropriate action, Your Lordship. Your Lordship, in the instant case, the accused person who is behind the bars, his wife had an alleged affair with the informant's sister's husband, that is brother-in-law, Your Lordship. Thereafter, Your Lordship, on that particular night, some fire has arisen in a nearby shop. Taking advantage of that entire situation, they have lodged this affair, Your Lordship. There is no damage to their house or their property, Your Lordship. It's a nearby shop. And only to eliminate the previous enmity whichever was there with regards to the extramarital affair, the affair has come into place, Your Lordship. Moreover, there are no independent witness as it is 2 a.m. in the night. Only the informant is also claiming that his father alone saw the person running away at 2 a.m. in the night, Your Lordship. Therefore, there is no other parameters which the investigation can fruitfully come to a conclusion, and already he is behind the bars, Your Lordship. Kindly at this stage, if it can be considered, Your Lordship.
My lord, there is dispute is there between the parties, but he set the house of the shop of the petitioner fire regarding that evidence is there, man.
Not petitioner's shop, Your Lordship, someone else's shop, Your Lord. It is written in the
No, my
FIR.
lord. Your lordship may kindly come to page
Gautam
14, my
Ghosh.
lord. And grounds of it, the incident is said to have arisen due to a long-standing quarrel between the complainant's sister's husband and the accused, allegedly over an extramarital affair involving the accused's wife. In a fit of aggression, the accused allegedly committed the act of arson, resulting in destruction of the Gautam Ghosh shop by
Gautam Ghosh
fire.
is different.
So because of that, he set fire the
Why will I set fire to someone else's shop, Your Lord?
eyewitnesses support.
The eyewitness is the father of the informant alone, Your Lord.
Who is Gautam Ghosh?
Somebody XYZ person whose shop is nearby to the informant's house, Your Lordship, not connected to the informant, Your Lordship. They have only taken advantage of such a situation. They have brought this entire. The Gautam Ghosh would have been an informant also. It would have been a correct proposition, Your Lordship. Gautam Ghosh is not the informant. The informant is someone whose brother-in-law has an affair with my wife, Your Lordship. I am the victim here in the instant case, Your Lordship. But the entire situation has been turned over, Your Lordship.
Whatever you see the line, I don't know.
Page 15, my lord.
Brief of the case in arisen so and so it is there. In a fit of aggression, the accused allegedly committed an act of arson, resulting in destruction of Gautam Ghosh shop by fire.
Hey, Gautam Ghosh is nowhere related, but incident, dispute is between both the parties, informant and the accused person. But at that point of time, he set fire the house of the probably house of.
Where then Gautam shop is there mentioned here?
Probably he set fire in the house of the Gautam Ghosh at that point of time.
Gautam Ghosh shop, Your Lord.
Gautam Ghosh shop.
Nowhere related.
Why? Nowhere related, but why he set fire on the Gautam Ghosh house, only CD will reveal. Otherwise,
And that part also, Your Lordship.
eyewitnesses stated that seen the accused fleeing from the place of occurrence immediately after the incident.
Eyewitness is the father of the informant, Your Lordship. Nothing else. Own father of the informant.
Gautam Ghosh has not lost the affair, but maybe a third party. But why he set fire the shop of the Gautam fire only Gautam shop's that only CD will reveal.
Your Lordship, if I may be allowed to go on interim also, Your Lordship, because there is no way a case is made
Where
out.
from it has to come?
DA, long copy, any short date may be fixed. I can get it. Lanka. Who's that?
He is in custody since
Since
7th.
12th of, today 12 days behind the bars. On 7th May, your lordship.
You can try.
Yes. बहुत अच्छे.
He doesn't. He gave us.
On 5th of May also, मैं like 5th of
Saying that 5th is a hearing, they already matter. has been
8th of
fixed.
May.
6, there are many matters,
Many
7 many. 8 is not a holiday.
9th is a holiday, your lordship. 8th.
9th. Then 11th.
Okay, then 8th of May.
Deeply obliged.
May I please your lordship, for it is application lordship. The FIR is at page number 19 lordship. The allegation is about recovery of fake Indian currency lordship.
Recovery of
Fake Indian
fake
currency lordship.
Indian currency. Achha.
From a vehicle who is standing outside the lordship in front of the house of the petitioner lordship. The interesting fact is that he is neither owner nor driver of this vehicle lordship.
Why
The
he got
recovery
arrested?
was made about at 11 p.m. lordship, at night hours lordship, when he was sleeping with his family inside the house lordship. At 11 p.m. lordship, police knocked his door and called him outside, and thereafter he has seen this incident lordship.
Now,
I have
during
annexed the
investigation-
vehicle owner details lordship as page 22 lordship, which is downloaded from Prohibitions lordship of my upload.
What is it? It is what?
Vehicle owner details lordship I have downloaded from the
Achha, detail owner of the
Prohibitions
vehicle.
lordship. This is lordship owner information. Let me see lordship. Owner name image. Yes, lordship R Ali lordship. The petitioner is Shabdul Ali.
So why it is, it was parked in your
Lordship, I
house
have
or-
no nexus with it.
Huh?
Already I was sleeping inside my house, Lord.
No, no, why it has been parked in your house? The
I don't
vehicle
know,
was
Lordship.
parked.
It was standing outside my house, Lordship.
That's why it was parked in the
My house
campus.
is located in the roadside, Lordship.
We don't know, we have no.
Abdul
nothing
Ali,
in-
he handed over those FICN to one Sajida Begum. And on that night, police recovered and that he is the owner of that auto in his premise.
He's the owner of?
He is the owner of that vehicle, wherein those.
If I was saying that he is the
and,
owner,
lord,
Lordship, but
that vehicle was also found in his premise.
That is the question.
I was not
Because
aware about the
a
fact.
He is
vehicle
directly
which
related, ma'am.
is such kind of fake currencies
Yes,
notes were parked in your house.
No, my house is located.
You are the person who handed over all these fake currencies to the.
This is the allegation, Lordship. The
So this is the
allegation is
allegation and that is your
still
submission.
showing
What
that
to
he is the owner, Lordship. But the vehicle information details saying that owner is another person, Lordship.
Maybe you brought those things in the said vehicle.
Yes.
Maybe owner may be in that.
Lordship,
Owner
for
may be in
kind consideration, if I have taken the position, then if I kept in top of the Lordship vehicle, Lordship, it was recovered from the top of the vehicle, Lordship.
Supposed to carry to the other places. That's in the night hours it was parked. Supposed to carry in the other places in the morning hours. Anyway, you are in the
And he is
parts
also a
instead of-
habitual drug trafficker from my lord. He is also a habitual drug trafficker also, my lord.
Hmm.
That is also.
The allegation which is I'm facing trial.
All are
Lordship.
these allegation. What to do? These are not proved. Allegation. And your submission is also your submission merely.
Yeah.
Nothing is there. When it can be
On
And
21,
short-
21 by 21.
19,
short-
19, 5.
95 will do. 19.
Can it be 12 or 13, Lordship, if possible? Lordship?
Huh?
Can it be before 10, Lordship?
Before 10
No,
also. my-
no date is there. That's why.
Obliged, Lordship.
Lordship, the FR is at page 9. The family dispute. 326G of BNS has been alleged of
FRA
burning
page
down.
9.
Huh?
Page 9.
Page 9 is the FIR. Only alleged section is 326G. With due respect, Kashmiri Gogoi, a resident of Paniville village, would like to inform the husband gets drunk and has been torturing me for at least 5 months. He often beats me and threatens to kill me. It is what mentioning that yesterday on 28 to 2026, he burned down our kitchen. He even tortured his parents and then tried to confront them. Therefore, I request the authorities to kindly look into the matter. Personally, Lordship, I've been on this charge, Lordship, I've been there for 58 days behind custody, behind the bars. Now, Lordship would see the house that is alleged to be burned is not a building. 326 is for a building, it is my own house. Lordship, there is
When you
no.
got arrested, 1-3.
Yes, Lordship, a forwarding report is there, Lordship, at page 16.
Yes, kitchen cannot be considered as a dwelling house, obviously.
It cannot be considered as a dwelling. Moreover, that kitchen is not a building. Lordship would see the Caesar list. It's made of toko leaves. Lordship.
Not
It was a
only
toko.
whether
So, and it is my house. Why I will burn it? It's my kitchen. Therefore, this 326 would not come into play. Secondly, I have been already there for 58 days. Lordship.
the destruction of any building which is ordinarily used as a place of worship or as a human dwelling or as a place for custody of the property. So kitchen, my lord, comes under that, my lord.
Firstly building, and it's a kitchen, not a human dwelling.
Kitchen.
Anyways, but I am there for 58 days, Lordship. That is one thing. And no torture, nothing, no injury report, and even it is not alleged. In the only 326G is there. So it was not my intention. It was just out of accident. The fire took place, but it is not accident, Lordship. Therefore, only some parts is burned. It is not like this, Lordship. The fire took place, but it is purely on accident, no intention.
Hard Mr. PP Gauhati, also hard Mr. People, it's an application, section Swenson, connection. Next, submitted to Mr. Porter, the president. There was a dispute between the parties, and with some false allegation, the FIR has been lost against the present petition. However, there is no allegation of any torture, although now not there is a medical report. But only materials brought in the FIR is that he set fire on the kitchen of the kitchen of the military kitchen of the Indian kitchen. Further submitted that the kitchen belonged to him and there cannot be any reason to set fire in the kitchen of his own house. However, the petitioner is in custody since last 58 days and is considering his length of detention. He may be released. Mr. Bott, next, Mr. Bott, the done petition has been submitted in this report that the kitchen is also considered to be a place where the properties are being kept, and hence he submitted that section 326G affects the present case. According this, insisted to call for case time. Next, for hearing this submission, will have any counsel for both sides. May proceed the case and the length of detention already undergone by the petition. This court is of opinion that I have had sufficient opportunity to interrogate the accused petition, keeping him custody. As part of his detention and the very purpose. It is CGM Dibrugarh?
Yes, Lordship.
Okay, you are granted bail, CGM Dibrugarh.
Yes.
Ting Kong. P.O. Bogarhat. Oh, no, sorry.
For bum.
Huh?
Borbam, Lordship.
or
Police PO,
Yes, CGM Dibrugarh.
CGM Dibrugarh, Police Outpost Borbam.
yes, Dibrugarh, na?
Yes.
Then CGM Dibrugarh.
Yes. Dib-
May I please your lordship, this is 483 bail application. This is a matter connected with Majuli PS and the allegations are abatement of suicide. Lordship, kindly call the case diary at this moment.
So petitioner got arrested on 10/4.
10-4.
Yes, Botakun,
On my lord. 2020 May.
20 May,
25.
2028 of May.
Lordship.
Lordship, bail application. FIR is on page 15, Your Lordship. May I read the FIR, Lordship?
Page 15.
Yes, sir.
Yes.
With due respect, I have the honor to inform you that Miss So-and-so, aged so-and-so, is my daughter. She is a student of so-and-so school. Today on 9/4 at about 4 p.m., my daughter went missing from our home, while I, along with other family members, had gone to cast our votes at such and such school. After searching for her, I came to know that one boy, namely Mannan Ali, son of Nurul Islam, resident of village Polashpuri, Gosaingaon district, has abducted my minor daughter and concealed her at an unknown place. Therefore, I humbly pray for the investigation. My Lordship, this is a case of juvenile relation, Lordship. Both the parties mentioned here, the boy Mannan as well, he's also a minor and they were in love, and so they went somewhere and then this case was registered. The petitioners before your Lordship are the relatives and co-villagers of the accused as well as the victim. So what happened after this FIR was lodged, the police contacted us, the father, the cousin, and other co-villagers, and accordingly, we went before the police on our own volition. We appeared and we told them that we have no knowledge that such and such thing has happened, and we are fully ready to cooperate with the investigation. After hearing us, the next day, the police ended up arresting us, Your Lordship. Whereas we are not anyway either implicated in this or in any way connected. Your Lordship will also come to the bail application that was filed, and on page number 31, Lordship, and it says that the victim has been recovered. Her statement has also been recorded. So it's no longer a case that the victim has not been found, Your Lordship. And secondly, in rejecting, while considering the bail application, the learned trial court has not observed that there are any such incriminating materials. Further, section 137(2) is also bailable in nature. That is also he is observed. And he's also made an observation that considering that both the parties come from different faiths, there might have been an issue in case he had granted them bail. So there was some apprehension on part of the learned court in trying to assess the matter. So the learned court did not grant the bail at that stage at all. But in no way in the bail petition did the learned court observe that there are incriminating materials against the present petitioner, Your Lordship. And even in the FIR, only the minor son of one of the petitioners has been implicated, Lordship. And they were already arrested, and all whatever the interrogation and information that would have been needed by the investigation agency has already been derived, Lordship.
In which para it is written that she got the girl is already recovered?
Para 8, page 6, para 8.
No. It is there, no, in the order, any order is there?
Yes, Lordship. Lordship may see page 26. It also said that they had attempted, the IO had attempted to add POCSO to this, but the same pair was not entertained at this stage. And 183 of statement of the girl was recorded. Further on page 27, Lordship will see that a bond had been taken for the production of the victim as well. She is currently in her own father's custody.
Yes, what?
Your Lordship, here victim was missing since 9/4 and after my lord, and recovered only on, my lord, 17 or after 9 days, my lord. After 9 days, my lord, on 24. And your Lordship may kindly come to page 20, my lord, bail ejection order dated 11/4/26, page 21, my lord. From the sufficient prima facie evidence has been collected indicating that the arrested accused persons were directly involved in the commission of the offense by facilitating the kidnapping, abduction of the minor girl, so and so, 15 years and 8 months. Although, my lord, at that point of time, POSCO was not added, probably not having the, maybe at that point of time, birth certificate was not produced. My lord, this is a pure case of POSCO otherwise also.
Lordship, the victim was recovered on 11/4. And whether POCSO has to be added or not is a discretion upon the trial court. And since at this stage it has not been added, therefore we cannot go on the presumption that elements of such offense are there. And on hold, please postpone as of now 20 days.
What about the prayer? After prayer was made, most probably then when the court observed that the perusal of 183 is necessary.
Yeah, 183, yes, my lord. Perusal
Before
of the 180,
adding section under POCSO.
yes, yes.
So what is the next date? Is there any POCSO?
Oh, yes, well, after 183, my lord, recording of 183 statement, whether POSCO is added or not, my lord. That will have to be, my lord. Now, he will have to get the instruction from the, because so on 17/4, at that point of time, my lord, 183 BNS was not recorded on 17/4.
But order of last page, your lordship will see an order for 24/4 is there. And the sections remain, your lordship. The last page, page 33. That is after 20th, your lordship. And as per our instruction, the girl was recovered on 12th, not on 20th, your lordship.
It's okay. She got already recovered. So whether adding of section is don't know at this stage.
Regarding that, my lord,
On 24, the court also observes that case diary was also received and he heard, but no observation regarding the addition of POCSO was mentioned, your lordship.
that is.
Even after going through the case diary, your lordship.
Otherwise, suppose if it is not a case of POCSO, then your petitioners may not be involved in abducting the
Yes,
minor
Lord.
girl, but I don't know whether there was any intention of the other person.
Because
Also.
that is the
So
only
there are
the,
many instances where
yes,
the parents or the family members are also involved in abducting
Yes,
the
but
girl.
your
And
lordship-
there may be
Yes, your
possibility.
lord. But the unique facts in this
Yeah,
case
I will
is, your
get the
lordship, that
instruction.
once the FIR was registered on 9th, 11th we have gone to the investigation agency and 12th we have been arrested, your lordship. So had it been our design in order to conceal it anyway, we would have not produced ourselves, your lordship. And I am one of the petitioners, your lord, before your lordship is the father and another is the cousin. The co-villagers going to give their evidence is still a different aspect, your lordship, but the father and the cousin were present. And on page 31, your lordship will note at the
Okay,
end.
then do one thing, Mr. Potaku. You want
Yes,
any instructions here?
yes, I will get the instruction, your lordship may fix it on my lord 2nd of May.
2nd of May.
2nd or 3rd, sorry, Saturday, my lord, on 5th of May, my lord, I will get the instruction.
Maybe on 4th also.
Okay.
Maybe on 4th of May then.
Yes, my lord, 4th also, my lord, I can get it.
Because tomorrow is the only working day, it will not be possible.
Yes, yes. 5th would be convenient, my lord, because immediately after, because 1, 2, and 3 holiday, thereafter 14th, 5th, my lord, I can.
Your lordship, there are good grounds for granting bail in the present case.
Also thinking of, but let us see, take the instructions first.
Yes.
5th
On
of May.
5th, I can get the CD also, my lord. I will try
Will
to.
be if CD not
Oh, yes.
also in that case also you take instruction, we'll
Yes.
pass the order.
Yes, CD.
5th of May corridor. In the meantime, CDP called for and the additional PP will also take instructions as to whether the case has been registered under the POCSO. List accordingly. Okay, we're listing it on 5th of.
Yes.
Lordship will consider bail in case the CD is not received.
We'll see to it.
Obliged.
May I please, Lordship? Not 483 petition, my lord. Already 44 days behind the bar, my lord.
44
Lord,
days.
44 days, my lord.
Oh.
My lord, the petitioner no way involved in this case, but he has the relation, business relation with the husband of the Ezahar Kari, my lord. And in the sense, my lord, he visited somewhere, some days in this house. My lord, Ezahar filed, my lord, that she has 7 years old son, my lord. And he is unable to work for 3 and 4 months, 4 months. That is why I approached the petitioner that you have you any known person for Kobraji? And that is why he given the address of the two Kobrias, my lord. One from Udalguri, another from Nagaon, my lord. And a mobile number also given, my lord. And they contacted the our mobile, my lord, and bring the two Kobrias. And the Yazharkar stated that she was paid 7,50,000, my lord, for cure of the son. And after 3-4 months, my lord, when the son was not recovered, then she demanded the money. And that is why 2 lakhs rupees returned by the two Kobrias, my lord. And in between this, my lord, petitioner have no any relation, my lord, regarding that transaction, my lord. So I am absolutely innocent, my lord. I am 44 days behind the bar, so I may be allowed to go on bail, my lord.
No, he is shown arrested in this.
Shown
case,
arrested, yes.
Arrested only, shown arrested on 16/3/26. And my lord, he's a fraud, my lord, actually, my lord, either concealing his identity, my lord.
Now, regarding this another case, my lord, that in that case he was released on bail.
Projecting himself as a tantric, my lord, misappropriated a huge amount of rupees, 7,50,000 from the, my lord, victim.
That was admitted by the Kobrias, my lord, that they were taken, and among these two, 7,50,000, my lord, 2 lakh rupees returned by the Kobrias, my lord. And petitioner only relation, busy relation with the husband of the Ezahar Kari, my lord. So he is absolutely innocent, my lord, in this case. Already 44 days behind the bar, my lord. FIR is page, my lord, 810, my lord. And relevant portion is 15 to 16, my lord.
Sixty-four is there, but 64 ingredients is not there.
Projecting him, he also concealed his identity, projecting himself as a, my lord, tantric, my lord. Thereafter, those amounts he has taken from the, my lord, and earlier also criminal antecedent is also there against.
Some money was stated to be returned.
Yes.
It's returned.
In fact, he admitted, my lord, the amount of rupees
2 lakh.
2 lakh,
One.
well, he already
1 lakh.
returned 1,50,000.
And 50 lakhs in online.
Demanded they taken
7,50,000
from me and my husband. Out of that, she paid 3 lakhs. And the rest of the amount. In other case, what is the position you have got bail?
One.
No.
In another case, the petitioner was released on bail from the Dhubri jail, my lord. On 31st, no? On 31st of March.
Is there in 44 damage demand? But Mr. B is not done a petition. So but Mr. B was done a petition. You bring on status. It's an application, sequence will connection with Swens. Next paragraph is submitted by Mr. Islam, the deputy. He is no victim in the He has only some business transactions with the husband of the informant. And as per the request, he introduced some persons as a uh, as a kabiras for their child who is unable to work. That effort he is not connected with the instruments. However, on demand made by the informant, he already returned rupees 2 lakhs to the informant, which was alleged to have been taken by the person who was doing the Kabiraji in the house of it. However, the accused petitioner got shown arrest in the case, and since 16/3/2026, he is in custody, and hence considering his period of detention, he may be released on bail as the Ayog got sufficient opportunity to interrogate him, keeping him in custody. However, the petitioner is still ready and willing to extend his cooperation in further investigation of this case if he is granted with the privilege. Next, Mr. Portfolio United Additional People submitted that he was also earlier arrested in similar kind of offense, and rupees 7.5 lakhs have been alleged to have been taken by the present petition along with the others, and hence the CD will reveal the actual facts. Next, but considering the submission made by learned counsel proposals, without going detail into the merit of the case, only considering the length of detention already undergone by the petition. This court is of opinion that I have got the opportunities to interrogate him. Hence, further the interrogation may not be required for the purpose of investigation. In view of this court bail the it is CGM to be. Okay, you're done.
Judicial Magistrate First Class Kokorazaman.
Judicial Minister First Class?
First Class Kokorazaman. Judicial Magistrate First Class Kokrazar.
No, CGM Cooper.
CGM.
CGM Cooper. We have received your affidavit.
Initially, this matter was listed on 23/4/2026, Lordship. And your Lordship was pleased to fix the matter on 30. But tomorrow, I have some difficulty, so I made a prayer for preponding the date. Accordingly, this matter is listed today, Lordship. Here in this case, what happened, Lordship, there was some dispute between husband and wife, and because of that, Lordship, some dispute arose, and that your Lordship will find in paragraph 4, I have elaborately stated, two incidents occurred. Lordship. One, Lordship, that altercation occurred, and the other husband and wife dispute. Two disputes are there. And paragraph 5 also, I have elaborately disclosed those husband-wife dispute. Now, in connection with those dispute, Lordship, she probably filed one case in Jalukbari PS. And accordingly, I filed one bail application, and your Lordship was pleased to protect the petitioners. That order I am just handing it over to your Lordship. There also no case number was there, no FIR information was there, and I have to file one bail application before this honorable court. And now, Lordship, I came to know that All-Women Police Station police is also searching for me. I am apprehending that probably because of that matrimonial dispute, some other affair, or including matrimonial dispute and the present dispute, that All-Women Police also may have registered one case. Because All-Women Police have jurisdiction all over Assam, Lordship. So they also have jurisdiction in Jalukbari PS, under Jalukbari PS, residents of under Jalukbari PS also. So that is my apprehension.
So I asked, that's why it was kept for thing.
Yes.
In two For the one person for the same incident, you're saying two cases.
So
that
regarding,
registered
they,
two
they
days.
may, they may have registered in the alleged two incidents. That FIR copy I do not have. They can bring the instruction. Because Lordship, that matrimonial dispute is also there and one altercation also took place. That your Lordship will find paragraph 4 and 5. Two incidents I have mentioned, Lordship. So what they have stated there, I do not know, Lordship. Therefore, I am apprehending arrest in two PS case, and I cannot pay for a bail in connection with two PS case, Lordship. So therefore, I have to file two separate applications. That the main dispute is husband and wife dispute. There, because of that, Lordship, some altercation took place. So for altercation, they might have lodged an FIR before the Jalukbari PS. That your Lordship already protected. And if they allege matrimonial along with that altercation, then all women police will have the jurisdiction. So they may have lost that case there also. Because Lordship, I have filed one additional affidavit also. I have filed one representation to the Old Woman Police. They refused to accept the representation, and they said that you people come personally. So that also raised a suspicion that any case may have been registered in the police station. Old Woman- আৰু সিহঁতৰ ফালৰ পৰা আসামত jurisdiction থাকে নহয়। সিহঁতে তাত women-ৰ related হ'লে লৈ ল'ব পাৰে।
Then, my lord, on that day also, my lord, the same accused person, he, my lord, filed two petitions, my lord, in Jaluk from. So where from I will get the instruction? On that day, he got interim protection in respect of, my lord, from Jalukbari PS. Now he stated that, my lord, I will have to also get the instruction from Panbazar Women Police Station. At this stage, my prayer before lordship, okay, my lord, I will get the instruction, my lord. But my lord, no interim protection can be granted, my lord, because already in Jalukbari PS, already he is already protected. How an accused person can be protected in from
Yes,
in
that's
every police station?
So not every police station, Lordship, but because of that, Lordship,
station now you're seeking.
no, all of
Here
it police
also
station
they are
regarding the same informant, Lord. Not any, not blanket order I am seeking, Lordship.
Otherwise, the case was
Lordship,
registered 30.
yes, Lordship may specify that aspect also, that name of the informant also. I am not seeking bail in other cases, Lord. No course of action against other cases. That informant's name I have mentioned, that Monju Begum, that part Lordship may clarify that if any case is registered by Monju Begum, then I have no course of action. That part I am only praying, Lord. Not a blanket order, Lordship may specify that part. Paragraph 4 is there, Lordship.
No,
That
in
my
Jaluk,
wife
we've already got the
protected,
protection.
Lordship.
Now, in this case, we cannot give you protection in everywhere. Where?
Yes.
Well, Monju Begum.
By Monju Begum, because I do not know where she has lost the case. Because both police police station are coming to my house, Lordship. Even my representation, they refused to accept, and they said they come personally to the Old Woman Police Station, Lordship.
Well, your lordship may kindly fix it on 6 or
Because
7.
otherwise
but
they are
may
government
get
employee.
instruction from both the police station whether any case registered against the present petition. Already in Jalukbari, he is protected, my lord. So from all women, my lord, I will get the instruction.
And that submission already I have made before that officer in charge, Lordship. Lordship may kindly see my representation, Lordship, and close along with the affidavit, Lordship. There also I said that no coercive action is directed in Jalukbari PS case. Kindly accept my representation, and they refused to accept, Lordship, because I am not protected in this case, Lordship. And she may have lost FIR, Lordship, with different allegations also. That I do not know, Lordship, because of the same incident. Altercation is there that I am admitting that she may have, but if she had some matrimonial dispute, then all women police will have the jurisdiction, Lordship. That is my only apprehension, Lordship. And they are government employee, they will not pay, but if they are arrested, then they will suffer irreparable loss. That is my only prayer. In additional affidavit, I have enclosed their identity cards, Lordship, and one is student, Lordship, that also I have enclosed. So only because of that reason, I am apprehending. I am not seeking bail in any other police station, only these two. Because all women police have jurisdiction all over Assam. They can register it. Only till report, Lordship, may protect.
I will get the report on my 6 of May.
Mr. A. Abetment. If I report, we go. Good. But Mr. A. Abetment. All right. So, report for the edition. It's an application for PLS. is submitted by Mr. Abetment. One another seeking some interim period in connection with Jalupari police station as put as he was by the Jalupari police station. Then the petitioners are also in Alake daily. Present the petitioners are also like all of the police station. Hence the petitioner has the apprehension. Petitioner has the apprehension that another case might have been lost in all of the police station. He further submitted that there is a suspicion that for altercation and for matrimonial dispute, the informant on Begum I have approached both Parliament police station for matrimonial dispute and the police station for the case of altercation. Further submitted that some of the petitioners are recommended and one petitioner is also stood and hence some interpretation will be provided. However, the petitioner has already filed their representation before Parliament police station apprising about the order of apprising about apprising all the metrics, but the Parliament police station refused to accept their representation and asked them to appear before the Parliament police station person. Mr. Gauhati PP submitted that cannot be a blanket order for protection in the station for a petitions. He will get the report from the Parliament station. The next hearing is submission made by the seen that earlier this petitioners got some interim protection in case of Jalupari case, and the present petitioner has been lost with an allegation, some lost that there is a probability of lodging any FIR before all of the police station for their matrimonial disputes, as the all of the police station has the jurisdiction for submission. This take any course and further the additional PP is thereby directed to call for the report from all of the police stations to whether any case has been registered against the petitions. Petitions. Estimated when it can be listed for court of 6th.
6th of May.
6th of
Lordship,
interim protection we have.
Oblige, Lordship.
May, Lord, this is Lord PDRS bail, and your Lordship will find the FIR at page Lord 15. May I read this Lord FIR? I have the honor to state that about 11 years ago, my maternal aunt, namely Origina Begum, aged about 29 years, was married to the below noted accused number 1. After the marriage, they lived peacefully domestic for several years. During the conjugal life, 3 children were born to them. However, since last 3 years, the accused person have been frequently demanding the money and motorcycle as dowry, and have physically assaulted my maternal aunt multiple times. They have been socially compromised to ensure the everything and in hope of their so and so. Last on 5/2/2026, about 12:30 am, at the residence of the below noted accused person, as failing for the receipt from the previously demanded dowry, the accused person with their pre-planned manner tied my aunt to a wooden chair and assaulted her by hand and foot. and forcefully made her consume poison. Consequently, after the fighting for her life for 3 days, my aunt passed away on 7/2/2026. The accused person are now frequently threatening to kill the victims' family members if my legal case is so and so, so and so, so. Now, this is the incident. Now, Lordship, kindly see, we have explained the Lord situation, how it was happened. Lordship, kindly see at page Lord 5, para 5, Lord. Page 5, para 5, Lord. That the petitioner begs to state that the accused number 1 in the present FIR has been residing about 500 meters away in a separate house of the accused petitioner's house since last 6 years. As such, the accused petitioner could not visit so and so as well as the accused number 1 frequently. The incident occurred on 5/2/2026 at about 12 so and so in the house of the accused number 1. The husband of the deceased thereafter immediately took her to the hospital for treatment. But on 7/2/2020, the time of the wife passed away while she was under treatment, and the affair was lost on 10/2/2026. 5 days after the said affair has been lost, thus harassed the present accused petitioner, and as such the petitioners are falsely investigated after third just to harass and the case also. Now, Lordship, kindly see para 7, my lord, how it was, my lord, held. That the petitioner begs to state that the wife of the accused number 1 in the present affair, wife of the accused number 1 consumed poison on the count that the husband accused number 1 of the disease is a drugs addicted person. The wife of the accused number 1 tried to modify him from the drugs addicted, but she had not modified at all. And as such, they had disputed amongst themselves, and accused number 1 was not earning properly, and his mind only went to the drugs. Apart from this, 3 children are going to be, that was not in his mind. As a result, the victim family faced financial hardship. That was the main issue, and after failing to modify her husband, she decided to suicide. And accordingly, on 5/2/2020, after sleeping all the children as well as her husband at night and so, the accused consumed poison. After consuming the poisons, the victim started hue and cry. Thereafter, the native villagers came to the place of the occurrence, as well as the present accused petitioners also, and immediately took her hospital. But on so and so, victim accused person so and so, so and so. Now, this is the situation, my lord. The accused number 1, we are not for accused number 1. My lord, he is, my lord, direct addicted person. Because of that, my lord, frustration, my lord, she, my lord, consumed poison. My lord. Now, at this stage, my lord, may I pray, my lord, CD may kindly be called for. In the meantime, my lord, the accused number 1, who is the, my lord, in-laws of the victim, and accused number 5, that is the mother-in-law of the, my lord, victims, my lord, they are aged people, my lord, they may be protected, my lord. Others, my lord, may be given privilege bail, my lord, after using the, my lord, CD, my lord.
Yes, ma'am. Otherwise, there is allegations against all the petitioner regarding demand for dowry. And my lord, regarding my learned friend, my lord, senior friend, my lord, my paragraph 5 and 7, my lord, he stated that they were residing 500 meters away. It is, my lord, very vicinity of that area, my lord. 500 meters is not too far, my lord. There cannot be a ground that in their separately meeting, my lord. Then they could not come and harass. There cannot be a ground in paragraph 5.
That is their submission.
That is there some, and paragraph 7 also, my lord. If we believe to be true that the wife is so worried about the family and the 3 daughters, my lord, she would not have taken poison just because the husband is not improving himself, my lord. So at this stage, he may be confirmed. On PC on the
We are praying for, my lord, accused number 1, who is, my lord, my lord, petitioner number 1, who is aged about 71 years, the, my lord, father-in-law of the, my lord, victim. And, my lord, accused number, my lord, petitioner number 5, Romesa Bibi, mother-in-law of the, my lord, victims. So these 2 persons, others are, we are not, my lord, praying at this stage.
They are the main culprit.
My lord, it is alleged in the affair.
They are the main. CDP call. Trying to give a short date, we are not giving any interim. Yep. 11th of May.
11th of May.
Yes, no protection is.
Considering the age group of this
71 years is quite young. 71, 58 is a quite young person.
71 years is
Yes, yes, yeah.
obliged, Lord.
Please, your lordship. Lordship, the item number 9 can be taken up along with item number 33 and 34.
3 and
It is
34.
available in those items, my lord.
Just
Related matter arising out of the same FIR, my lord.
9, no?
33 and
Taken
34.
up along with 33.
yes, 33 and 34.
When
34.
it is called. Ready to call on order?
Obliged.
May it please the lordship. Here, my lord, the petitioner have, my lord, business relationship with my lord one Farid Ali, my lord. And
Okay.
during the distress of financial distress of my lord Farid Ali, my lord, he borrowed a sum of rupees 13 lakhs and 19 lakhs from the petitioner, my lord, and returned, my lord. He mortgaged to dumper vehicle with the petitioner, my lord, with a condition that my lord, I will pay the remaining EMI, and my lord, upon completion of the EMIs, my lord, he will, my lord, transfer the documents in my favor, my lord. Thereafter, my lord, on 19/3/2026, page 14, my lord. Page 14, my lord. Said, my lord, Farid Ali sent a advocate notice, my lord, in favor of the petitioner.
Hmm.
Stating that, my lord, page 14 is the notice, my lord. It was dated, my lord, 19/3/2026, my lord. By this notice, my lord, he stated that, my lord, he taken a loan of rupees 10,000, 10 lakhs from me, my lord, and with a condition that, my lord, I will operate the vehicle, my lord, and will pay, my lord, per month 50,000 to him, my lord. Now I am defaulted, my lord. Accordingly, through this legal notice, my lord, he, my lord, my lord, requested to give back the vehicle. And thereafter, my lord, page 19, my lord, page 19. Kindly see, my lord. A complaint was, my lord, uploaded in his WhatsApp status, my lord, complaining that, my lord, I have, my lord, illegally, my lord, possess his vehicle, my lord. And on the other hand, my lord, on 22/04/2026, my lord, page 24, my lord, and I received a notice from, my lord, Uriamghat police station, my lord, and mentioning GD entry number, my lord. It was issued under section 94 of BNSS, my lord, whereby, my lord, I was directed to appear before the before the police station, my lord, along with some documents, my lord, on 20, my lord. My lord, my representative, I sent my representative along with my document on 20th, my lord. But police, my lord, did not accept the documents, my lord, which I have sent, my lord. And on the other hand, my lord, threatened my representative, my lord, to my arrest, and also, my lord,
No, you appeared.
I didn't appear, my lord. My authorized representative was appear, my lord. But but those documents were not accepted by police, my lord. And on the other hand, my lord, it was threatened my arrest, also, my lord, to cause, my lord, physical torture, my lord. And therefore, my lord, I have filed this application, my lord. And on the other hand, my lord, civil suit is also pending before the, my lord, civil judge, my lord, between the, my lord, petitioner and, my lord, said, my lord, Farid Ali, my lord. Now, my lord, my lord, pray for protection, my lord. If any case has already been, I inquired, my lord, on 17, my lord, no case has been registered till yet, my lord. Therefore, my lord, let
Bring
the,
a
my lord,
report,
learned PP maybe
We'll bring a
take
report.
instruction, my lord. Whether any case has been registered, my lord, for any FIR, my lord, in respect of, my lord, two vehicle, my lord, by Farid Ali, my lord. And in the meantime, my lord, I may be protected, my lord.
On page 19, my lord, he was directed to appear, my lord, because my lord, the two numbers of dumper yet to be recovered, my lord.
On the basis of
But
Lord.
GDN.
GD&D, he was there, and he has sent one of his, my lord, one of his representative, my lord. But it is not for his arrest, and it is not a,
I will
my lord,
appear, my lord.
it is not a, my lord, notice, my lord. It is only a,
For
so he
production
could
of
have,
some document.
yeah, he
Document.
could have appeared, my lord. If there is no case, my lord, he would not have been arrested.
I will appear, my lord. Although, my lord, I was not appeared, my representative was there, my lord. He was appeared, my lord.
but that was not accepted, my
So-
lord. I have clearly mentioned in my lord paragraph 6 of my petition.
Part District Keyboard. It's an application section related to be an submitted by Mr. Burke. There was a agreement for vehicle and the petitioner took the vehicle and he was supposed to give the EM. But in three of it, paid to deposit the EM for which one notice was also served by the client. And a civil dispute suit is also pending with. However, he received a notice from the petition on the basis of the GD entry 16 dated 20/04/6 section 94 of BNSS. BNSS. Accordingly, the petitioner sent on his representative with some relevant books that by the police and is such and for which present petition has been petitioner is still investigating officer if any case has already been raised against him. Mr. Report may be called from William Station in places of police station as to whether any case has been registered against the petitioner under William Police Station DD entry number 16 dated 20/04/6. Let a detailed report be called for from William as to whether any case has been raised against the petition. Strength of DD entry number 16 dated 20/04 till the receipt of the case diary. The concerned police station is hereby asked not to take any corrosive action. Let the matter be listed when it can be called.
Mala 15.
15. 50 top.
In the meantime, my lord, I may be protected.
Yes, we are here, will be under some protection. Corrosive action is not asked to take step.
And in the meantime, if he is asked to appear or submit any document,
he
he
can.
may cooperate.
Yes.
That may be
Further, the petitioner is hereby directed to extend his cooperation and to file any relevant documents if required for the purpose of investigation.
Abduction. Pre-arrest bail application, Lordship.
Yes.
Lordship will find the typed copy of the FIR on page 10.
Page 10.
Yes, sir. May I read the FIR?
Yes.
Respected sir, on 19/1 at about 6 p.m., my brother so-and-so, after closing its shop at so-and-so place, was returning home. When he reached near Debatar Kopati, the above name accused person wrongfully restrained him and started assaulting him with sticks and da. Upon receiving the information, when I rushed to the spot to intervene, tried to rescue my brother, the accused persons also attacked me. Due to the assault, my brother Sufaullah Mandal sustained serious injuries and became unconscious. Thereafter, he was first taken to Goripur Hospital for treatment, and considering seriousness of his incident, he was referred to Dhubri Medical College and Hospital, where he is presently undergoing treatment. Your Lordship, the case revolves around market between two groups of people. Now, we were implicated in the FIR. All the petitioners are FIR named, and it has been projected that serious injuries have been caused. And therefore, sections such as 118(1) and 118(2) both have been given here, like voluntary causing hurt with weapon and voluntary causing grievous hurt also with weapon. Other two sections are available, Your Lordship. So at this stage, I would only ask that the CD be called, and if any injury report is there, that may be called to justify the addition of the grievous hurt.
We'll
If
call
any
for the
grievous hurt is caused, that may be verified through any injury report if the IO has collected with the city.
Then we're calling for the case diary along with the medical
medical
report.
report.
of the case. CTP call along with the injury report. When
On
they are
14,
not
my
on interim,
14 হবো না?
14 will do
14.
1/4.
Can
Early,
They are not on interim.
date
11 not
early.
can be given.
11th.
Okay.
obliged.
May I please?
Okay, Bhavan Rama. Yes, 51.
My lord, may I please your lordship? This is pre-arrest bail application. The
Yes.
FIR lordship will find at page number 13, 1-3. May I read?
Yes.
Respect sufficient is that above noted accused number 1 has been in love affairs with me since last 4 years. On last 16/4/2026, accused number 1 came to my house and took me to his house with a promise that he would marry me. Later on, after accused number 1 reached his house, other accused person sent accused number 1 to somewhere else. After the boy went away, the accused persons rebuked me with indecent languages and threw me out, pushing from the house of the accused number 1. After assaulting at my back and waist by kick and fish blow, accused number 2 and 4 blew a hard kick blow in my private part. So this is the allegation. So the actual fact of the case is that, my lord, on the pretext of being in love affairs with the accused petitioner number 1, my lord, that she voluntarily went to the house of the petitioner. In fact, the petitioner number 1, he stays at Bangalore, my lord. He is working as an assistant cook at a hotel. And since last 4 years, he has been working there, since last 2022. I have annexed the certificate as well, my lord. So, admittedly, my lord, they are Facebook friends, my lord, admittedly. And there are some online chatting in between them. But physically, they have never met. So, in the last month, my lord, on account of the, my lord, just concluded election, assembly election, my lord, the petitioner number 1 came to his house, my lord. And then, my lord, while he was in his maternal uncle's house, my lord, on the date of occurrence, on 16/4/2026, my lord, that the informant voluntarily went to the house of the petitioner, number 1. And in fact, the petitioner number 1 was not at home, my lord. And when she went to the house, my lord, the parents of the petitioner, number 1, that is the petition number 2 and 4, and other petitioners, my lord, they asked the girl as to why she went there. Then she said that, yes, I'm in love with the petition number 1, and he has asked me to come today, that he would marry me. So on that occasion, my lord, the petition number 4, who is the father, my lord, he called on the petition number 1. As he was in his maternal uncle's house, he came, a village panchayat was held, and the parents of the informant was also called on. There was a village panchayat. I have already named the person who were present in the village panchayat. But during the panchayat, my lord, she could not establish that she was in love affairs with the, my lord, and that she was in contact with the petition number 1. Because, my lord, generally, when a person goes for work in the Bangalore, they goes for either for 1 year or at least 6 months, they does not come back, my lord. And when he works in a hotel, my lord, then he rarely gets some leave, my lord. So only on exceptional occasions, they are granted leave.
No, sir.
So
So
far,
the FIR, my lord, first part is okay, my lord, whether she went voluntarily or not, my lord, that is the different fact, my lord. The later part, my lord, she was, my lord, assaulted in her waist and also in the private part, my lord. That is the matter of concern, my lord.
But so,
That is
to that regard, my lord, my humble submission would be, because for commit, my lord,
Also had
would cooperate with the investigation.
It's an application and the technical access. And so the submission made by this code is a interpretation. accordingly. Pay for the petition. Yes, you will be under interim protection, cooperate with the IU.
My lord,
When it can be? 21.
my lord, I am obliged.
Which number?
Before CD not received, my lord.
CD not received yet. No one has represented the petitioner. But Mr. P. Bot put it on an additional PP appearing on behalf of this one. And it is submitted that CD not received. Issue reminded.
On
When-
13th of May.
List accordingly and 30. 1-3.
One. 25 and 26, my lord, search sheet submitted in this case.
Oh, it was in the morning hours.
Yes.
Soma was there.
Yes.
Where is he now? Let it be on for time being then.
Yes.
Application under section 483 lordship. Offense under section lordship 87 of the Annex lordship.
We have received this scan copy here.
No, kindly taken up after some time, my lord.
We have to go through the case record.
Yes, yes. Can you report, my lord, status one notice
Yes, notice. What about the same?
POSCO case, my lord?
Yes, yes, obviously. You have to take instruction because your office has already received the notice
Yes.
on 20th of this month.
You will also may kindly take it up at 2, my lord.
You're going to take instructions
At 2, my lord.
at 2.
May it please your lordship.
Yes.
Lordship, the petitioner before yourself is one Sudhir
It was
Das, your
fixed,
lordship. He was arrested.
yesterday, no?
Lordship, it
For
was
today.
My lord, it was fixed yesterday. Actually, my lord, primarily it was fixed for the case diary on last Friday, on which occasion, my lord, we had just entered appearance by filing the wakalatnama, and the coordinate bench, my lord, whether the bail ought to be heard on that day itself, or whether, my lord, the informant should be availed the opportunity to file the objection, had heard at length and subsequently decided, my lord, that the points which the informant wants to apprise this court are probably worth giving an audience to. So as such, that opportunity was granted. Yesterday, we filed the affidavit, my lord, as directed, and lordship was pleased to fix it today, my lord. Let my learned friend submit, let the, my lord, public prosecutor
So
submit.
you have
the
already
diary.
filed your objection.
That is filed, my lord. I have checked, my lord. That is before your
One
lordship.
answer, no? To market your meeting. You have already received your objection.
Lordship, yesterday I have received.
On your request, most probably matter is fixed today.
Lordship.
You're saying that it is an urgent. Since when he is in custody, you're saying?
Since 6-3, Lordship, 6-3-26. 54 days behind bar, my lord.
As the case is under which section?
Lordship, sections are 406, 420, 465. The FIR is under those sections, and subsequently, my lord, 403 and 409 were added in my case. So
yes.
Yes. Lordship.
I, Sushil Kumar Khandela, am the proprietor of Sri Ganesh Trading, having its registered office at KK Colony, Jagirat, so and so, so and so. One, Sri Manoj Harlalka, who is a power of attorney holder of my firm, Sri Ganesh Trading, since 5/9/2009 to look after my day-to-day work by forging my signature, misappropriated the money belonging to my firm. My firm, so and so, was awarded 3 work orders from PWD, so and so, so and so, so and so, so and so. Your Lordship, I'll not trouble you. I'll come to page 17, where the allegation against me is made, Your Lordship. All the 3 aforesaid work orders have been executed and handed over to the respective PW department after proper completion. During the execution of all these works, the payments, bills, so and so, so and so, so and so, which is the correct and official bank account of Sri Ganesh so and so, is the operator and authorized signatory. I made an inquiry with the PWD department on 24/12/2024 regarding release of my dues from the department. To my utter shock, I came to know that the security deposit and the pending bills had already been released as per the records of my department. But said release was surprisingly not made into my duly authorized bank account, which was associated with respect to the aforesaid works, wherein the earlier payments were made. Rather, the payments were credited to 2 fake bank accounts maintained in the name of Sri Ganesh Trading Corporation in the Federal Bank Limited, Bongaigaon, which are operated by Manoj Harlalka, accomplice Sudeep Das, the petitioner before your lordship, so and so and so. Moreover, for the transaction in the said fake bank accounts, the mobile number so and so belonging to Manoj Harlalka has been registered for account number so and so, Federal Bank, operated by Sudeep Das, so and so, so and so, so and so. Now, at page 18, lordship, when we approached the Federal Bank Limited, Bongaigaon, via letter dated 2/1/25, lordship, which the informant has brought on record by way of the objection, requesting bank statement and account opening form for above bank accounts, and opening form for account number so and so, where the operator appeared to be Sri Manoj Harlalka alone. Again, the bank refused by issuing a clear letter dated 2/1/2025, informing that they could not issue the details of account number ending with 980 in the name of Sri Ganesh Trading as the proprietor is not Sushil Kumar Khandela, the informant, lordship, and the PAN number so and so is not added to the said account. Subsequently, my lord, what happened? These are the facts, my lord. Thereafter, my lord, the other co-accused, my lord, he approached this honorable court seeking anticipatory bail, my lord. The orders I have annexed. Lordship will find the interim bail order at page 33, my lord. This honorable court observed that there appeared to be a primarily civil dispute of civil in nature. Subsequently, interim was granted, and thereafter, in the month of January, my lord, the co-accused Manoj Harlalka was granted absolute anticipatory bail. Now, in that case, my lord, Section 409 was never a part of the FIR. Thereafter, I was arrested on 6/3 and I was served a notice, and in that 409 was added to skip the notice of 35/3, my lord, because Manoj Harlalka received the notice to appear before the IO. Subsequently, he approached this court and he got the bail. Now, what I am on, my lord, my prayer is very limited. I have been behind bars for 54 days. My role is that I am the employee of Manoj Harlalka, who has been granted absolute anticipatory bail by this honorable court after perusal of the CD and after due consideration, taking everything into account. So, why is my custodial detention necessary any longer, my lord? That is my humble submission. I will cooperate with the investigation in any manner required. I will abide any condition. And from the face of it, it appears to be a case of documentary evidence, my lord. I will produce whatever documents which are necessary. My humble submission would be that, my lord, my custodial detention may no longer be necessary. That is the sum and substance of my case, my lord. And to substantiate, my lord, I have given the book, the citation, lordship, 2022-10, my lord. Lordship has the judgment, my lord. Detailed judgment, my lord.
Yeah.
Page 76, my lord, para 12. The principle that bail is the rule and jail is the exception has been well recognized through the repetitive pronouncements of this court. This again is in the touchstone of Article 21 of the Constitution of India. This court in so and so, so and so, so and so. Lordship, ultimately, my lord, my limited prayer is that since the allegations is against the bank officials, the PWD officials, and the co-accused, but in the entirety of the case, only I am the person who has been arrested. This FIR was lodged in the month of August of 2025, my lord. Until late, I am the only person who has been arrested on 6-3. Only because of the fact that 409 has been added. And my specific contention would be that 409 is in no way attractive to me, my lord, because for 409 to exist, there ought to be an agency, my lord. And how can there be an agency? I have annexed the agreement between Manoj Hardalka and the informant. I am only the employee of Manoj Hardalka, my lord, who has been granted absolute interim bail by this honorable court. So that is the sum substance of my case, my lord.
The account was opened in the name of Sheikh Manoj Halalka.
My lord.
And you are also
Allegedly, my lord.
My lord, with lordship's leave and leave of my senior colleague, my lord, if I may submit what the informant wants to bring on record, my lord. Because whether custodial detention is further required or not, my lord, that possibly is not a call of the informant, my lord. That is a call of the honorable court, my lord, with assistance from the people. My simple role, my lord, is to come to the court with clean hands and place facts which possibly are not already before your lordship as on date. My lord, may take up the petitioner's bail application as already pointed out by him. At page number 16, my lord, are these three work orders. Now, my lord, the informant, Sushil Khandelia, he happens to be the proprietor of the firm Sri Ganesh Trading. Sri Ganesh Trading is situated at Morigaon, my lord. My lord would find the document there is probably in the case diary also, and is there in my my lord submissions as well. So Sushil Khandelia, proprietor of Sri Ganesh Trading, based out of Jagi Road. That firm has been awarded these three works. Now, in the progression of these three works, Sushil Khandelia, my friend has correctly stated for the petitioner, has employed Manoj Harlalka for carrying out some of the works, for which I will pay him, my lord. At page number 17, my lordship, in the second paragraph, it is clearly stated that during the second line of the second paragraph, during the execution of all these works, payments, bills, etc. are to be made into account number this, State Bank of India, Sonakuchi branch, Jagi Road. This SBI account happens to be the account of Sri Ganesh Trading. So work executed, PWD as per norms will submit to the account of the proprietorship firm. That is how it was going on. Then subsequently, my lord, where the criminality comes in, my lord, the Manoj Harlalka and Sudeep Das, my lord, both these persons, because I'm not aware and there is no material on record to the extent that I am aware of, that my lord Sudeep Das is employee. Both are in connivance that I am aware of, my lord. So two accounts, one ending with my lord 980 and one ending with my lord another that 2341. So the 41 the red account, that is Manoj Harlalka. What he had done is, my lord, that is in the name of Sri Ganesh Trading only. That is my firm. He, by forging a document, has added himself as a joint operator. And Manoj Harlalka has subsequently managed with the PWD office for the certain amount to be sent into that account. So that is Manoj Harlalka's part, where he has entered himself as a joint operator in the account of Sri Ganesh Trading. And my lord, he has taken the money in that account instead of the official account of the State Bank. Then, my lord, another Sri Ganesh Trading is open. That is why, my lord, I sought permission to file this actual affidavit. Because, my lord, this is not an issue of copyright. At page number 60 of my additional affidavit, lordship would find a Sri Ganesh Trading by same name maliciously is opened at Bongaigaon, my lord. Same name. And this Sri Ganesh Trading's name, my lord, another bank account is open. That bank account being, my lord, the one ending with 980, my lord, that is at page number 64 and 65. This bank account, Sudeep Das operates, my lord. Absolutely no connection with the work, my lord. Manoj Harlalka, still you can understand that he had an agreement, my lord. Sudeep Das never ever did the work order, never a part of Sri Ganesh Trading, opens another Sri Ganesh Trading in Bongaigaon and takes the money, my lord, security deposit or bill payments of the work order of the Sri Ganesh Trading of Morigaon, my lord. And when the actual owner, my lord, writes to the bank at page number 65, my lord, and 66, it is stated that we will not give you accounts of these details or how much money PWD has given, because the informant, he was told that you are not even the owner of this firm, you are not the operator of this account. This is Mr. Sudeep Das's account. This is where Sudeep Das comes into the picture. Work order somewhere else, public money, my lord. Work order awarded to someone else. Account opened, firm opened in Bongaigaon, account opened in Bongaigaon, and entire money amounting to 1.5 crore, not the entirety, but major part of it diverted to that account, my lord. My lord, now labors are to be paid. This is not only affecting the informant and his firm, my lord, probably goes into deep rooted, my lord. Labors are yet to be paid, hundreds of laborers. And they are seeking from Sri Ganesh Trading of Morigaon, very rightly so. I employed them. But bills, my lord, taken away and siphoned off by, my lord, two other persons. Now, my lord, probably my learned friend has also stated that Manoj Harlalka being the prime accused and him probably being his employee. My lord, to that effect, I have no instructions, my lord, him being the employee. But when Manoj Harlalka obtained bail from this honorable court, my lord, it was an offense of 60 days, my lord, the default period being 60 days. Subsequently, my lord, 409 came into the picture. That, my lord, informant has no control over. Today, there can be a missing case report, my lord, where the punishment is maybe up to 5 years. Then, my lord, if that person is found to be deceased tomorrow, then 302 will come, then it will become a different offense. That is as and when the investigation progresses and new material comes to light. And with regard to Manoj Harlalka, lordship, even though in the anticipatory bail order, my lord, that our objection is not mentioned, but my lord, I am duty bound to tell this court, my lord, though not myself, my lord, the informant, not at the time of interim granted, interim was granted, informant was not aware, but at the time of final hearing, my lord, the informant chose to appear, but the coordinate bench was of the belief that, my lord, that because he is already interim granted, appeared, and it is not an offense of 90 days, my lord, so the matter was disposed of at that point of time. My name does not appear, but it is my duty. I am apprising this court, my lord. And my lord, at the time of Manoj Harlalka's hearing also, even if certain facts have been misrepresented, this is not the platform, my lord. I have to seek another recourse in law, and that, my lord, I have already undertaken. So Manoj Harlalka's is a very distinct case, my lord. And rest of the details, my lord, with regard to this account number 980, what all is there, my lord, that my learned friend, my lord, the public prosecutor would be able to submit. And if, my lord, all the material are not before this court, then, my lord, for as an abundant caution or in the interest of justice, my lord, the entirety may be directed, my lord, investigating agency, because today my learned friend has said it's 54 days. It's a matter of 90 days, my lord. The investigating agency has been provided with another 36, 37 days by the legislature and by this court, my lord, to complete their job. So for abundant caution, my lord, I'm not seeking rejection even today. If that is sought for, if entirety is not before your lordship, then that may also be resorted to, my lord. Rest I leave to my learned friend, my lord. Obliged.
My lord, in this case diary received, my lord. Yes, my lord. Initially, one allegation against two persons, one Manoj Harlalka and the present petitioner, my lord, Deepak Das. And from the statement of the Sudeep Das, my lord, from statement of the, my lord, Manoj Harlalka and my lord Sudeep Das, after obtaining interim, his statement recorded. Statement, it reveals that he is the employee of, my lord, prime one accused, my lord, Manoj Harlalka, who was earlier granted interim protection. And regarding, my lord, they were both argued regarding heading of section 409. I would like to point out to your lordship, my lord, Manoj Harlalka was granted interim protection on 8/12/25, my lord, page 33 of the petition, my lord. Now I check the, my lord, case diary that section 403 and 409 added on 1/12/2025, my lord. That is, my lord, at the time of granting interim protection, my lord, on the first day interim protection was granted, and the cause title also regarding, there is no mention about section 409, 403, my lord. So on that day interim protection granted, and my lord, thereafter, my lord, absolute bail granted to the petitioner accused number 1, Manoj Harlalka. And regarding those allegations, my lord, main allegation is that, my lord, there is contract between the, my lord, one of the, that is the accused persons, my lord, where in fact power of attorney is there, my lord, as per the contents of the FIR of the there by the, my lord, by the informant to the accused person Manoj Khandelwal, my lord. And Sudip Das is the employee of the my lord, Manoj Khandelwal, my lord, Manoj Harlalka, my lord, Manoj Kumar Harlalka. And my lord, the PWD contract work, my lord, was allotted to my lord informant. There are 3 contractual works, my lord. At that point of time, Manoj Harlalka was the power of attorney holder for execution of the works. And during execution of the works, my lord, from the contract, those my lord amounts which were paid by the my lord PWD department, received by the all where my lord transaction was made for the joint bank account holder of the my lord, the petitioner is also my lord. The informant is also well about those accounts were transactions were made in the account that is joint account of Jagirot branch. And now the allegation is that both the main allegation is that by forging the signature, by overwriting the signature of the informant, these accused person Manoj Harlalka has opened a bank account in Federal Bank Bongaigaon branch by Manoj Harlalka and Sudip Das. Thereafter, after completion of the work, the security deposit amount and maintenance amount which was supposed to be received from the PW department and the pending bill amount, those were directly received by these accused person in those bank accounts without the knowledge of the informant. In fact, those accounts were also in the name of the Ganesh Trading Company, who is the proprietorship of the firm is the present informant. Now, initially, interim protection was granted. Now, IO has stated that, from the present status of the investigation is that investigation is still going on. IO has, till now, the note of the IO, the arrested accused Sudip Das has stated that he used to hand over and frequently handed over, this is, I will, the arrested accused person in his statement, Sudip Das, present petitioner, has stated that he used to hand over and frequently handed over self-attested documents such as his PAN card and Aadhaar card to his employer. So he is Sudip Das is an employee of the main accused person, Manoj Harlalka. So, he handed over all his documents thereafter, in his name also, Sudip Das' name also, bank account is there,
Bank account is there means he is just Mr. Boyd just submitting that one forced account is open.
Regarding that, investigation is going on. Police has, the last note of the IO, the original account opening form of the said bank account is yet to be collected and forwarded to the FSL for examination. So whether that, bank account has been forged by these accused persons, regarding that aspect, only FSL report will reveal, regarding yet to be collected and forwarded to the FSL for examination. So, that original account opening form of the Federal Bank of India, Bongaigaon branch, not yet collected by the IO. And that report was submitted by ID IO in the present CD on 23/4/26.
No, just the counsel for the informant has submitted that one account has also been opened in Bongaigaon.
Yes.
The name of Ganesh Trader.
Yes.
By the present petitioner.
By the present petitioner, that is the allegation of the present petitioner. Yes, by two accounts were open in the one in the name of Manoj Harlalka and one in the account holder Sudip Das, and but name in the name of Sri Ganesh Trading Company. That is the allegation of the present informant. Regarding that aspect also, those account opening forms were not yet collected. After obtaining interim protection, he appeared, and his statement recorded by the IOML. And in his statement, he stated that being an employee of the main accused person, he handed over all his documents. Thereafter, he actually shift responsibility to the main accused, Manoj Harlalka, by taking all his documents he opened in his that bank account, because otherwise he is Manoj Harlalka. The accused number 1, Manoj Harlalka, also stated that Sudip Das is my employee.
As per my instruction, only thing that is bank account ending with 980, my lord. Here neither his so-called employer Manoj Harlalka, whom they are trying to project as the prime accused, he is also not an operator. The informant Sushil Khandelia, he is also not an operator, my lord. Sudip Das of Sri Ganesh Trading appears to be the sole operator. But my lord, I cannot place that because lordship has seen, my lord, I have sought all the entire records, and page 65, my lord, it has denied because bank will of course say that this Sri Ganesh Trading is of Sudip Das. Why will I give to Mr. Khandelia? And unfortunately, my lord, probably investigation is
still yet progress to that extent. That dash account of form, if it was placed before your lordship today, lordship would have taken a call directly, my lord. But here it is only till my thing or submission or the my lord the counter submission of my learned. Whether that is required, my lord, because the amount in question is 1.48 lakh, I leave it to lordship.
I am not projecting Manoj Harlalka as a prime accused.
No,
In the,
in my lord. Because learned
Yes.
friend is in my lord for the petitioner, my lord, not the learned.
but
He is
Mala,
facing FIR facts, my lord. I have nothing to say.
If a short reply, my lord. Lordship will take up the absolute bail order if kindly, my lord. At page 38 of my petition, my lord. At para 7. Learned senior counsel reiterated that the dispute is primarily a civil dispute which has been given the color of a criminal case. It is further submitted that in terms of the agreement dated 27/2013, the petitioner was proposed to get 33% of the profit of the works undertaken on behalf of the informant. The same has not been given to him. It is also submitted that the relevant documents have not been sent to the FSL and his handwriting sample has not yet been taken in, and in this context it is submitted that all the documents are genuine and he has not committed any fraud or forgery with regards to the document. It is also submitted by the Linear Senior Counsel that all the alleged offences are punishable so and so. At para 9, Lordship. I have considered the submissions and perused the statements of the accused materials on recorded by the IO after grant of interim bail and available in this case diary. In the said statement, he has stated about his business relationship with the informant and about maintaining of a joint bank account at Federal Bank where all work-related payments were deposited. He stated that upon completion of all works and receipt of all payments, no dues remain pending between them. But later, the informant filed cheating case upon him, which is false. Para 10. He further stated that the informant was aware of all the transaction. It appears that the petitioner and the informant had a business relationship, and in the course of the same, some works were to be undertaken by the accused petitioner. There appears to be a civil dimension to the matter, but whether criminal liabilities are made out or not be a matter of investigation and the outcome of such investigation. So, Lordship, what the informant does is that he does not pay my employer the dues which he is to get after that. Thereafter, he files a case against me. Ultimately, my lord, the informant has annexed page 65, Lordship. Now, upon perusal of this, does it reveal that I am anywhere my name, does it come up? It has been said 1,000 times that I am allegedly I am the operator, but whether in the case that there is any material to show that I am the operator of the bank, of the said bank account. The FIR was lodged on 8/8/2025, Lordship, and the informant who sent this application on 2/1/2025, which is already perhaps part of the case diary, sought time on Friday to bring it on the record. Why was it necessary, Lordship? Perhaps it could have been part of the case diary itself. So what I'm on, my lord, if Lordship takes up the IPC, Lordship, my only contention is that in no way 409 would be applicable to me, my lord. So considering the fact that I have been behind bars for 53 days, Lordship, whether my custodial detention is necessary, and it was submitted that there are only 2 accused persons in this case, my lord, which is perhaps incorrect. If Lordship kindly takes up the FIR again, the FIR is against all the PWD officials involved as well as the bank employees. But the whole investigation appears to be silent on that. So why me? Why am I the one behind bars? And it is their admission that I'm an employee of the co-accused, my lord, who has been granted bail. Now, understandably, parity is not a ground in all cases, but when on the face of it, the facts appear to be apparently of similar in nature, parity ought to be a ground to be considered, my lord. Just because 409 has been added arbitrarily, my lord, is not a ground to deny me bail. That would be my humble submission, because 409 in no way the ingredients of 409 are attractive to me.
Is there. You have mark, flag mark is there.
Yes, sir.
Part Mr. 54. Vedant. Part Mr. 54. And about the denial of appearing for the it's an application submitted to built we connect the stop. He was working made as an employee under who was to the 3 work order which had been received by the informant in the name of Ganesh Trading. He further submitted in regards to opening of account, what do you want to say?
Sure.
In regards to opening of account,
Lordship, one account has been operated by Manoj Harlalka from the allegations, and the other, my phone number is given because my employer has given my phone number in that bank account as per my instruction, my lord. My phone number has been registered in that.
one account is obviously by Manoj Harlalka.
Lordship.
The other account?
Lordship, as per my instruction, it is not operated by me. My phone number has been given.
Communicating address of his shop is there regarding that in that account. Communicating address of the present petitioner, madam, that is shop of the present petitioner to be
Was there in the bank account?
yes, yes.
But it's that one account is allegedly opened by one of the co-accused Manoj Harlalka in the name of Ganesh Trading, which is he is operating, and in other account which is alleged to have been opened in the wrong account, wherein the phone number of the petitioner is provided in the bank account, though he is not at all operating the said bank account. He was only an employee under the co-accused Manoj Harlalka. He has no role in the LS office. Further, the co-accused Manoj Harlalka and another one Manoj Harlalka and other who got the bail?
No, Lordship.
Manoj Harlalka,
Only Manoj Harlalka and Sujit Das. They are the named FI people. Others are the bank employees and the PWD employees.
We get that one co-accused Manoj Harlalka, who is considered to be the prime accused of the present case, has already got the bail of anticipatory bail score, which was granted to him on result of his death. He is the only person who got arrested in connection with this case, and he is behind the bars since last 54 days, and thus the IO got sufficient opportunity to interrogate him, keeping him in custody. Also, prior to his arrest, there was after his arrest, only 409 IPC has been added, and added only to make a case to arrest the present petitioner without any prior notice. However, there is no such ingredients affect the ingredients, or however, there is no such material or ingredients against the present accused petitioner to affect section 409 IPC, under which which has been added after his arrest. He further submitted that he is still ready and willing to extend his cooperation, and also ready to provide all the documents before the investigating authority in part for the further investigation of this case, if he is granted with the privilege of it. Next. Mr. Waterford Ilane petition submitted in this regard that that it's fact that the present accused petitioner was an employee under the other co-accused Manoj Harlalka, but there are sufficient materials against the present petitioner, wherein the phone mobile number of the present petitioner is also given while opening the bank account in the name of the Ganesh Traders, which is a proprietorship firm of the during the investigation, it found that the code is required to be added 409 of the 409 IPC, and accordingly the same section is added and added. Investigation is still under process, and hence at this stage, further custodial interrogation may be required to unearth some more facts of the case, wherein some bank officials may also be involved in the Mr. Court would accordingly raise objection submitted in a case, extend present petition. Next, Mr. Vaidya did not still obtain for the information in this that the Ganesh Traders is a proprietorship form of the informant, where co-accused Manoj Mandalka was appointed to represent his firm, and in connivance of the present petition, along with the bank official, he opened two accounts in the name of Ganesh Trading, whereby Ganesh Trading and Ganesh Trading he was authorized to look after the 3 work orders, which was three offers, which was in favor of which were given in favor of the informant, and after completion of the money was also deposited in the bank, but in connivance with the bank officials and the present petition, said Manoj Kandar had opened one open an account in the name of proprietorship firm, where what was the account he misappropriated? 1 point.
That account, Lordship. That account, Lordship, would find at the additional affidavit, page number 65, my lord.
What was the amount, you say?
My lord, that amount I am not told directly.
1.4 crore.
1.48 lakh is the total amount that is misappropriated in both the accounts.
1.48, na?
1.48 crores. So a portion of that, what I am told, a major portion of that has gone into the account operated by Sudeep Das ending with 980. Because the bank is not giving me the account statement as because I am not the so-called operator and he happens to be the operator. So I do not know the exact amount that has gone into the account.
But gone into the account of Sudeep Das?
Sudeep Das, operated by Sudeep Das. Because
Operated by
when seeking details, he said that we will not give details to you. This is mobile number is Sudeep Das's. This is operated by Sudeep Das. If Sudeep Das comes
in Bongaigaon.
In Bongaigaon, Federal Bank Bongaigaon. The letter is there, man, directly denying me that we will not give you any information. It's my money.
If my address and phone number is there, so admittedly, he is operating.
It's that. Property share firm and another bank account wherein to account. And another bank account is also open in the name of proprietorship firm, Ganesh Trading. Ganesh Trading in the name of Ganesh Trading, wherein the present petitioner was operating the said account in Bongaigaon, Houston. It has come to the knowledge of the informant that around 1.48 crores has been misappropriated by operating these 2 bank accounts, and the bank accounts ended with 980, no? Bank account ended with?
My lord, the entire
Bongaigaon.
My lord, Bongaigaon account ending with 980. The
980.
entire account is kind of if I may provide the account number.
Okay, but 980 is okay.
980, ending with
And
980.
they ended with 980 is seems to be operated by the present accused petitioner, wherein his mobile number, etc., were also found in the bank statement. However, the bank did not give the detail of the account or operated by the present petitioner as well as Manoj Kaldalkar, even after filing of their representation before the bank. Mr. Vaidya accordingly submitted that there is sufficient materials against the present accused petitioner who is operating one bank account wherein good number of very huge amount of money misappropriated in the name of Ganesh Puri. Mr. Buddha, according to his objection, has submitted that this may not be a big case to enlarge the accused on bail at this stage. Okay, I have recorded your submission. I'll go
Yes.
to the case.
Well, I would like to point out one thing. Well, IO in his first portion of the CD, while submitting the bail objection, he has stated that bank opening form yet to be collected for sending it to FSL. Probably he has not collected the original of the bank openings form from the bank for sending it to FSL, but some photocopy is there in the CD.
My body for submission.
But he has not used the word original there.
Submitted that protocol submitted that during investigation, the IO collected the bank accounts form. But it is yet to be, but those were yet to be sent for FSL for examination. Examination and investigation still are. That's okay. We'll pass your charge.
Highly punished.
Okay. We have marked the flag mark, huh? Flag mark is already
Yes,
there.
ma'am, flag mark.
Before us.
Some of the flag marks are already there by the IO.
Pardon?
By the IO, some of the flag marks is already there. in the
Okay.
some.
28.
Wait, please, Your Lordship.
It's
My lord, on the last occasion, Your Lordship granted time to my learned friend, the counsel for the CBI to produce the case diary.
yes.
CD has come. I'm
Yes. Okay. You can submit it. Yes, please.
My lord, my submission with Your Lordship that if Your Lordship comes to page 16, which is the FIR, Your Lordship will recall, my lord, that it was regarding a suicide committed by a young lady engineer, my lord.
Oh, yes.
And this
yes.
FIR was lodged by the, my lord, sister. May I read that, my lord? Page 16. With due respect, it is stated that today, when myself, my mother, and family members were calling my sister Joshita Das, who was working as assistant engineer PWD Bongaigaon subdivision, but she did not take up any phone calls. Then we got in touch with her landlady and her other acquaintances at Bongaigaon, and when they entered her house, it appeared that Joshita Das had committed suicide in her residence near a petrol pump, Borpara, Bongaigaon. With regard to the suicide, she was under tremendous and undue illegitimate work pressure from her seniors, colleagues, contractors, including architect Devojit Sharma, SDO Aminul Islam, executive engineer Dinesh Medi Sharma regarding some mini stadium project. She was forced, coerced, criminally intimidated, and threatened to prepare and pass estimates and bills in irregular manner, which took severe toll on her for which she had to take this extreme step and thereby putting an end to her life. It is pertinent to mention herein that from the last few days, my sister Joshita Das was informing me, as well as my parents, regarding the illegal pressure and demands she had been facing from her seniors, colleagues, and contractors. She further disclosed before us that her senior colleagues, contractors were asking her to do some works which are against the work policy of the department, and when she objected or failed to do the same, they asked them to leave her job and or ridicule her being incompetent in her works. When she disclosed the undue work pressure she had faced to her seniors, they also did not help her, rather rebuked her and asked her to do the works as per their wish and also harass her mentally. The information which was conveyed to me and my parents by my sister Joshita Das regarding the undue workload and illegal demands she had faced in her office prior to her late forced Joshita to take this extreme step, and she had no other option had left to her but to end up her life. Now, my lord, your lordship has seen there are three names, my lord, of her senior officers and my lord, one architect. My lord, all these persons have been, my lord, granted bail. Of course, my lord, two of them after arrested, after custody. And the father of the petitioner, he was the contractor in respect of the work of that ministerium. And he has also been granted bail by the Honorable Supreme Court.
And so far as the petitioner is concerned, my lord, he is an engineer. He is not my lord, directly, my lord, concerned with the work. He, being a civil engineer, my lord, he inspects works of many contractors, including his father, my lord, and there is no allegation against him. But then, my lord, when the police called him, therefore, my lord, he approached this honorable court, and this honorable court was pleased to grant him interim protection. So my prayer before your lordship is that, my lord, when all the accused persons named in the FIR are in, my lord, are granted bail, and my lord, there is no material in the FIR, at least, my lord, there is nothing against the petitioner. He should also be, my lord, that interim order should be made actually after perusal of the case diary. That is my submission.
May I please your lordship? This is a long pending case. However, the CD has, we have brought the CD and the process is under the filing of the final report as I got the information. So in this regard here, the petitioner is supervising the work of his father and he has been granted a contract of the stadium. So thereby he has linked with the contract work because he is supervising the work of his father. And father has been granted the contract by the same department where this lady was working, and she was under the very pressure with regard to passing of the bills or some for doing certain irregularity. So total summation of the case is that out of pressure from the department, she was compelled to end her life by way of suicide. So as of now, the process is going on for filing the final report with regard to the investigation, Your Lordship.
And regarding his cooperation and after obtaining the interim bill, whether he cooperated in
They are
investigation?
cooperating there. To that effect, there is as such no issue. Otherwise, I would have get the certain information, but they are cooperating. But that I cannot say in it is in the CD.
No, you peruse the CD, you say whether the cooperation is there or not. The duty to peruse it is there.
My lord, the case is registered under 108 of the BNS, which is, my lord, abetment of suicide.
Yes.
And, my lord, 35, that is joint liability. So abetment of suicide, my lord, that is the allegation, and, my lord, the petitioner does not come into the picture. And the persons who have given her pressure in the work, my lord, those are named in the FIR.
As and when he has been called, notice was issued. He appeared before
He
the
appeared.
IU. He appeared before the IU.
Notice means? Notice was issued means?
Means for the
Notice,
for examination, for the purpose of investigation. As and when he has been called for, he has appeared.
So he has been cooperating.
He has been examined here, see, as per the.
So I need.
He has been thoroughly examined, my lord. That is my
Yes,
instruction, my lord.
yes.
My instruction is that he has been.
চাব লাগে ইমান ডাঙৰ চিঠি এটা কৰিব লাগে স্কট request one. That means you have not perused the case diary. Now you are perusing why? Maybe voluminous in the earlier occasion also you took time. In the earlier 2-3 occasion also you took time for perusal of the case diary because obviously it is a voluminous one.
Yeah,
But
my
I have seen that you have not perused the case diary at all.
His investigation is complete now. It is under the process of
That is okay.
filing
That
of
is
the.
okay. What if, whether there is any involvement of the present petitioner in the case diary? Because so
N-
far
not
as I can
required, not
remember, he
required,
was
not
supervising
required.
the entire, the contract work by him only.
Yes.
Though it was the name of his father, he was supervising all the contract work.
Yes.
And the
Your Lordship.
pressure, whatever the allegation was against him also.
Yes, sir.
When I earlier perused it, now you are saying you have not perused anything, you're not submitting anything.
So as of now, he has cooperated and case diary itself said he has cooperated, Your Lordship.
Heard Mr. M.K. Chaudhary, learned senior advocate, assisted by
HR.
Huh? H?
HR.
কি বুঝাম কি করছে
H. HR. CHA.
কি করছে
লিখি দিয়া তোমার কথা বুঝে নাপায়
your good name, your good name.
Arnold. Arnold.
ঠিক নাম বলছো
কি করছে assisted by so and so, and also heard MS M. Kumari, learned standing counsel CPI. The senior standing counsel here.
No, standing counsel, retainer counsel.
This is an application under section so and so in connection with so and so. CD received, well received. It is submitted by Mr. Chaudhary, learned senior counsel, that the present from the plain reading of the FIR, it is seen that the present petitioner is not an FIR influence, where some allegation of work pressure to do some illegal activities were brought in the FIR, for which the victim had to take such steps. It is a fact that he is an in fact Nalagi, he is a civil engineer, and it is a fact that the entire contract work for construction of the mini stadium was granted in favor of his father, who is also a contractor, who was working as a contractor. That apart, he has no role or involvement in the finance department. He further submitted that all the co-accused persons have already granted bail, some with the regular bail and some are in absolute bail. And his father is also granted bail by the Honorable. He further submitted that there is no indictment to attract case against the present petitioner under section 108(3)(5) of the BNS. However, after obtaining the order of interim pre-arrest bail, the petitioner had appeared as and when he was called for and cooperated, extended his cooperation in the investigation of this case. He is still ready and willing to extend his cooperation if he is granted with the privilege of pre-arrest. Next letter. MS Kumari, the learned standing counsel, submitted in this report that there is sufficient progress in the investigation and the case is ready for submission of the final report. However, he submitted that though the work order was in favor of his father, who was a contractor, but the present petitioner was supervising the entire project work, and his involvement is also there in the case. However, he submitted that the petitioner had extended his cooperation and appeared before the IO as and when he was called for, and thus he is cooperating in the investigation. Next one, considering the submission made by learned counsel for both sides. I have also perused the case report, the case diary, and it is seen that there are some implementing measures against the present accused petition. However, considering the fact that the work has already been, the investigation is already progressed and at the stage of filing of the final report. And at the same time, it is also seen that petitioner had extended his cooperation and in the investigation of this case as and when he was called. Considering all these aspects of the case, vis-a-vis the vis-a-vis the vis-a-vis the And obviously considering the fact that the case of the present petitioner is under the same footing and hence on the ground of parity also, since the present petitioner entitled for a privilege of the registry. Considering all these aspects of the case, the interim pay granted to the present petitioner dated 27/10/2025 is hereby made absolute with same terms and condition with a further direction to appear before the investigating officer as and when his cooperation will be required before the filing of the file. With the above observation, the case stands to.
Alia.
My lord, can I just mention? No, not mention.
Okay. Well, sorry for troubling your lordship. I'm so sorry.
Ah.
But there is one matter. Mr. Leonard Pen has 22. My Leonard Pen has come from Mumbai. So if this a convenient date can be fixed by your lordship, any date, because the other side, we have filed the reply. No, we have filed the reply. Pleadings are completed, my lord. 23 or 28th of June, whichever is convenient. 28 is holiday, 23rd of June. 23, 23rd. Saturday night.
June. No.
June. 23rd of June. I am the petitioner. Objection has been filed by the respondent union. I file a reply to it, man. Already replied. Already interim may continue, my lord. There is an interim order which has been passed by the court. No, by the we have informed all.
Because here.
He suggested also, ma'am, Yes, my learned friend.
Is in report number 19.
But 20, yes, sir, we have informed. Yes. Assisted by my learned friend was come from Mumbai.
Why Jahangir?
Jahangir.
Why
Jahangir.
Jahangir?
Same. Oh, is it? CC. Yes. Yes, sir. Yes, there is an interim order there. Yes, we are given. The interim order will come. I am deeply obliged. Sorry for troubling.
Yes, my lord, and it was prayer, my lord. At item number 20, yes, that item was mentioned at 10:30 without my consent. I have not given any consent for adjournment. And that matter is just said is a part of, yes. Huh. No, no, no. Yes. Can you be listed tomorrow, my lord? It's a very urgent matter. Yes, my lord, it's a part of matter, but I'm telling you, my lord. But there is one notification, my lord. If the part of judge is not sitting for 1 month, it will be taken with another court. Is it? Yes, part of notification is there. Yes. We just took here. Can you fix a date, my lord? So 1 week. Can you be fixed by the date, my lord? It is 1 week. Yes. Huh? 12 বলে দিন।
Lordship. Lordship, item number 25 and 26, yes, my lord, these two matters may be taken up with item number 43 because arising out of same FIR. Yes, Lord, along with 43. I was on leg, Lordship, at that time. I was on leg. Extremely sorry, my lord. That's out of senior. Of legs.
Already received. 20 shares. Already received. Fifth or sixth worship. Fifth or sixth. Already TCR received and is behind the bar for more than 100 days. Can it be before that worship? More than one.
May I please your Roshan?
Item number, my lord, 30, 35 and 39, my lord, same thing. 30, 35 and 39.
The petitioner, your lordship, was. No, your lordship, on 39, 35 I am appearing, 39 I am not.
Your Lordship. No? The 39 ও appear করছে। Continue, sir. On all three, I am appearing, Your Lord. All.
The case they received, madam.
Interim, Your Lordship, our statement has also been recorded, Your Lordship, and injury report was called for, Your Lordship. আহিলে নেকি?
Report not yet received, but why injury received, madam, because of yes, yes. Otherwise, there are materials against the accused person. After obtaining interim protection, my lord, in item number 30, Asik Ahmed, and item number 35, Inamul Islam appeared their statement recorded. But regarding item number 39, my lord, Sohail Anam, my lord, his statement is not available in the case.
Probably, Your Lordship, custodial interrogation is not required, Your Lordship. This is because, Your Lordship, it's say on that day, particularly the Asik was not even named in the FIR, Your Lordship. And his vehicle was damaged and it is in the police thana, Your Lordship.
Statement of the injured is there, my lord. He in fact identified all the accused persons. Injured is also there. And other.
In fact, Your Lordship, what has happened in this case, Your Lordship, that these two groups, Your Lordship, belong to two different political parties, Your Lordship, apparently. And regarding a particular, at that point of time, Your Lordship, on that occasion, Your night, Your Lordship, some incident altercation had taken place. It is not that I will have to admit, Your Lordship, that both side has received injuries, etc., Your Lordship. But they have also lost the FIR, Your Lordship. That FIR has not been registered or not investigated upon. But still, Your Lordship, it is a heat of the moment that has occurred, Your Lordship. And it is not that it's a pre-planned, premeditated, Your Lordship, attack on any of them, Your Lordship. Therefore, since they have cooperated with the investigation, Your Lordship, my humble submission, Your Lordship, further custodial detention may not be required, Your Lordship. They have cooperated, thoroughly interrogated, and police has not called them again also, Your Lordship. And if anything is there, they will face the trial, Your Lordship, if something is found against them. Young boys, Your Lordship. And one is, Your Lordship, works in a pharmacy, Your Lordship. While returning from his shop, Your Lordship, this incident took place. So far as 39 is concerned, statement 11. We have been instructed that, Your Lordship, he has also, his statement has also been recorded, Your Lordship.
There is no record in the CD, my lord, regarding item number 39. A direction may be issued, my lord, to appear before the IOL.
Who will appear?
Sohail. He is accused number 1, my lord, in the FIR.
In fact, in my petition page, item 30, I have annexed certain photographs which shows the injury I have received, Your Lordship. Lordship. Lords, Lords, not Lords, Lords. Lords, Lords.
Deeply obliged.
Lords, 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 Lords. Obliged. Lords.
Deeply obliged, Your Lordship. Deeply.
May I please? My lord, in this case, my lord, your lordship was 31, my lord. You want CD not received, my lord. Petitioner is in interim.
interim, my lord. But as per my instruction, my lord, in this case, my lord, already charge sheet submitted.
He was saying,
Yes, my lord, one sent, my lord, but today, my lord, could not take, my lord, my mobile number, but number was also sent in my WhatsApp, my
yes, yes,
my lord. My lord.
on 11/5. 11.
Diploma. Please, Your Lord. Appearing in 9 as well as in 33, my lord.
Sure, I am appearing in item number 34. I am appearing.
Lordship may kindly take up 33 first. 33. There is an interim order, my lord, dated 25/2/2026. And in compliance with that interim order, my lord, as per my instruction, the petitioners appeared before the concerned IO on 3/3/2026, my lord. Now, Lordship will kindly come to the FIR, which is at page 17, my lord. In the FIR altogether, my lord, 22 persons have been named. The crux of the allegation is that, my lord, these persons entered into the residence of the informant, my lord, and specifically, he have stated in the FIR that the FIR named accused persons number 1, 2, 3, and 7 have assaulted the family members with the sharp weapon, and subsequently they sustained injuries and they were admitted in, my lord, SMCH, Silchar Medical College and Hospital. So their roles, the role of the accused number 1, 2, 3, and 7 has been, Lordship.
Subsequently,
Yes, my lord.
103 added. My
And on 20/12/2026, my lord, 2025, section 103, subsection 2 has been added as the one person has been died. So in this petition, my lord, the petitioners, there are two petitioners, both are working as a teacher in a private school, my lord. Lordship will find Annexure 3, page 24 and 25. So what happened, my lord? They were in the managing committee of that particular school, my lord. There was an altercation between the informant and between the petitioners regarding the admission of the son of the informant, my lord, grandson of the informant. So from that time, they developed certain enmity, my lord. These petitioners, my lord, this informant, they block one road, my lord, in the village, which is the Passage Road. And subsequently for that, your lordship, the villagers protested against them. And subsequently on that particular day, the incident took place, my lord. Our case is that, my lord, we were protested against that blocking of the road, but we were not involved in the assault. As there was this previous enmity, our names has been known to the informant, my lord. Our name has been implicated in this case. Lordship, the informant, they raised certain construction, my lord. Lordship, I have specifically mentioned informant blocked the road. Lordship, all villagers raised protest against that their deeds, my lord, and subsequently in the night, that incident took place, and he have implicated all the persons, the known faces of the village in the FIR, my lord, without attributing any act on the part of the petitioners, my lord. That is our case, my lord. Our name has been mentioned in the FIR in serial number, my lord, appearing in serial number 12 and 13, my lord. Minal Hussain and Altaf Hussain, my lord. Two petitioners. And so far, item 9 is concerned, my lord. Today is the motion day, my lord. The petitioner's name is appearing in
Serial number, my lord, 10. Farizuddin, my lord. Serial number 10, his name is appearing, my lord. So his case is that, my lord, he is a businessman, petty businessman, my lord. He used to give temporary stalls in the mela and fairs at different, my lord, the parts. So on that particular day, he was not even present in the village, my lord. He's one of the brother, my lord. His name has been specifically mentioned, appearing in serial number 7, my lord. Razu Ahmed. His role has also been attributed in the FIR also, that they have attacked them with a sharp weapon, my lord. So they belong to the same family, and he was known to the informant. Accordingly, his name has also been mentioned in the FIR. He was not even present, my lord, on that particular day in the village.
For your lordship. Ship, I have similar submissions to mate as my Johnny senior made. I am also businessman 11 and 19, your lordship. No specific role has also been attributed to me, your lordships. 11 is Abbasuddin and 19 is Kamaluddin. Both of them are brothers, your lordship. They are businessmen of the area. And the basic facts, as my learned counsel pointed out, your lordship, is that there is an END, there is a specific type of road which is constructed parallel to rivers for the movement of the villagers. Now, the informant has constructed houses on this embankment, because of which the villagers have also complained to the concerned deputy commissioner and other authorities. Now, on the fateful day, again, the villagers were protesting against the informant. And it is informants who came out with sharp weapons and tried to attack them. In the altercation, this thing happened, your lordship. The FIR thereafter was registered. But we are nowhere connected in the offense, and no overt act also has been attributed to us, also, your lordships. And we are also interim protection. We have cooperated with the investigation as per my instructions. The lordship may be pleased to make the interim protection as absolute.
Yes, my lord. Case diary received, my lord. Here incident initially, my lord, one incident occurred on 14/12/25, and thereafter, my lord, on 15/12/25, the present incident, my lord, all the accused persons, my lord, along with them, my lord, attacked all these, my lord, total, my lord, one. Along with all these accused person by my lord, attacking all these informant and other, my lord, victimized person with sharp dagger, stick, iron rod, batam, etc. on the day of the incident. That is on, my lord, 15/12/25 at about 10:30 p.m. incident occurred on that day. And thereafter, my lord, on 17/12/25, one of the victim, Sadia Akhtar, my lord, Sadia Akhtar expired, my lord. Age of the victim is, my lord, only 16 years and 11 months, my lord, minor, my lord. Is, my lord, PM report received. PM report, my lord, opinion regarding the cause of death is kept pending till the receipt of chemical analysis report of viscera from Regional Forensic Science Laboratory, my lord. That FSL report regarding cause of death, my lord, exact cause of death, final opinion, my lord, not yet received, my lord. And regarding one FSL report, that is viscera, that is received, no, my lord, toxic substance, that is regarding viscera, my lord. And regarding, my lord, involvement of all these accused persons, my lord, police has recorded statement of 183 under BNS, my lord. All, my lord, not only one witness, my lord, there are many witnesses, my lord. Eyewitnesses is also there, my lord. All implicated the accused persons that on that particular day, my lord, all these accused persons armed with lathis, my lord, stick, iron rod, all these accused persons at night, my lord, at about 10:30 p.m. attacked, my lord, all these, my lord, victimized persons, and on the next day, the one of the, my lord, victim, minor, in fact, my lord, he succumbed to her injuries, my lord, and many other person, one Suhaib Ahmed, Abdul Ghafoor, Abdul Kalam, Anwar Begum, and many other persons, my lord, injured. And regarding injury report, my lord, those injury reports, although not available in the CDI, today in the morning I tried to contact the IO, my lord. Regarding injury report, my lord, he has not yet, my lord, those injury reports is not available in the case diary. And otherwise, my lord, from the statement of the injured eyewitnesses, my lord, all these eyewitnesses, my lord, implicated all the accused persons. On that particular day, in a group, my lord, they entered inside the premises of the, my lord, informant, and thereafter attacked by, my lord, with all these weapons, my lord, and those weapons, some of the weapons also recovered. Regarding seizure list is also available, my lord. So there are materials against all these accused persons. They in a group, my lord. In fact, not only on that particular day, that incident occurred earlier also, my lord, in the FIR also on 14/12 also, my lord, in the informant also lost a complaint, but regarding that is mentioned in the FIR, my lord. And from the statement of the accused persons also reflect that which supports the contention of the complainant that on 14/12 one incident happened, my lord. And regarding that incident, my lord, on that day also there is some incident occurred in that particular place. They in fact entered into the premises of the informant. And thereafter on the next day, my lord, at about 10:30 p.m., these are some of the 183 statements of the, my lord. It would be okay. Or other flag mark portions also there, my lord. Many other witnesses, my lord. 183.
The accused are also known FIR and accused person. 115, namely alia, on the S on the living ID, include his injuries. Section 143. Yes, that's my lord. I have strong objection for this granting clear as well.
Lordship, before concluding, my lord, just like to take your lordship to the specific sentence which has been specifically mentioned in the FIR. Informant was, as per his version, informant was very much present at the time of incident at the residence, my lord. So he specifically made a statement, my lord, in the FIR that lordship will kindly come to page 18 of, my lord, item number 33, my lord. It is the translated copy of the FIR, my lord. In the vernacular also, the same thing has been written, my lord. Just I am reading out from last para, my lord. On last 14/12/2025, I lodged a written complaint in the police station regarding the same, for which the above named accused persons out of rage with an intention to kill me and my family members come in a group on 15/12/2025 at around 10:30 p.m. and illegally trespass into the dwelling house and the road. And after entering, they attack us with the sharp dagger, stick, iron rod, bolam, etc. and suddenly started assaulting us, for which my family members, namely Sadia Akhtar, Suhab Ahmed, Abdul Ghaffar, Abdul Kalam, Afzal Hussain, Anwar Begum, Mukhtarul Islam, Akhtarul Islam, sustained injury due to the assault inflicted by the accused number 1, 2, 3, and 7 by their sharp weapon. 3 persons, namely Sadia Akhtar, Soheb Ahmed, and Abdul Ghaffur, are presently admitted in the SMCH in an unconscious condition, sustaining serious injury. There was a protest, my lord. Villagers gathered there. They might be present there, but what is role attributed to them, my lord? Specifically, it has been mentioned, these 4 persons, mainly, my lord, that is number 1, 2, 3, and 7. They have attacked with a sharp weapon. This is the statement of the informant, my lord, who was very much present, and he was the eyewitness to the incident at his residence, my lord. So only merely because due to the presence, whether their custodial interrogation is necessary or not, lordship may kindly determine that factor. That is my humble prayer.
Present petitioner's name are Kamaluddin, Abbasuddin. That is, my lord, they are, yes, yes. My lord, regarding that, in that FIR, my lord, on the day of the, my lord, lodging the FIR may not, but from the witnesses' statement, already the present accused persons are FIR named accused, my lord, 10, 11, 12, 13, and 19. All these accused persons, but their names were, my lord, eyewitnesses and injured witnesses' name on the. Yes, 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 all relatively, yes. Those were injured witnesses also, my lord. Yes, yes.
M. Shah.
25/2/2026. In item number 33, madam.
In 34, it was 9/2/2020.
Item number 33, 25/2. Good. Oblige, Lord.
When the last official city was called for.
CD received, madam.
In a group fight, Lordship, husband of the informant died. Lordship, kindly see case 17. Vernacular portion, Lord. Case 17. 36. Case 36. May I read? Case 36. 17, sorry, 70, sorry. বিনীত নিবেদন এই যে 14/2/2026 তাৰিখে পুৱতি নিশা প্ৰায় 3 মান বজাত মাটিবাৰী বিবাদ লৈ তলত নাম দিয়া পদকীয়াগণে হাতত দা লাঠি টেগাৰ আদি লৈ আমাৰ মাটিত দলে বলে আহি আমাৰ মাটিত থকা ঘৰ বাৰী ভাঙি দি আমাক ঘৰৰ পৰা ওলাই দি আমাৰ মাটিখিনি দখল কৰিবলৈ তেওঁলোকে ঘৰ উঠায়। তেতিয়া মোৰ স্বামী হাছেন আলী বয়স 52 বছৰ আৰু মোৰ ভাতৃ ফাইজুল হক আৰু মোৰ দেৱৰ শাহজালাল উদ্দিনে বাধা দিয়াত পদকীয়াগণে মোৰ স্বামীক দেৱৰক আৰু ভাতৃক কাৰ্যকৰী লাঠিৰে মৰিয়াই শৰীৰৰ বিভিন্ন অংগত গুৰুতৰভাৱে আঘাত কৰে। 1 নং পদকীয়াই স্বামীক মূৰত বেয়াকৈ আঘাত কৰাত অজ্ঞান হৈ পৰে। আমি ৰাইজৰ সহযোগত স্বামীক চিকিৎসাৰ বাবে মংগলদৈ চিভিল হস্পিটেলত লৈ যাওঁ, যদিও চিকিৎসকে স্বামীক মৃত বুলি ঘোষণা কৰে। তেওঁলোকে মোকো মাৰপিট কৰি শৰীৰৰ বিভিন্ন আঘাত কৰে। আমিও মংগলদৈ চিভিল হস্পিটেলত চিকিৎসা লওঁ। তেওঁলোকে আমাক মাৰপিট কৰাৰ লগতে আমাৰ ঘৰ বাৰী ভাঙি চিঙি জ্বলাই দিয়ে। প্ৰকাশ থাকে যে মৃতকৰ সৎকাৰৰ কামত ব্যস্ত থকাৰ বাবে এজাহাৰ দিয়াত পলম হ'ল। Lordship, in item number 36, 3 petitioners before your Lordship. Serial number 4, Shohid Ali. Serial number 8, Rezzaq Ali. And Nazrul Haq in serial number 9. And in item number 37, Ekush number 1. Serial number 1, Abdul Jabbar. So, Lordship, I am appearing on both the items, item number 36 and 37. In 36, Lordship, on the last occasions, Lordship, your Lordship was pleased to grant an interim protection, Lordship, and pursuant to that order, Lordship, we have appeared and recorded our statement. So, for our informed that, Lordship. Oh.
Item number 38, I am appearing, Your Lordship. 38, I am for 5 accused persons, Your Lordship. Lordship, all are there, they are in custody, Your Lordship. Your Lordship, accused number 3, three, 5, Your Lordship, 7, 6, and 2, and 2 also. 2, 2, 3, 5, 7, and the other. Lordship. 2, 3, 5, 6, 7. They are in custody, Your Lordship. They are in custody since, Your Lordship, 16 to 22, Your Lordship. Prisoner 1 from 16 to 72 days behind the bar, and others are 66 days behind the bar. 72 days. And remaining 66 days. 66. And in this case, Your Lordship, there is a dispute between land here. Your Lordship, dispute between land. That civil case also pending. On the day of incident, the informant side came to our house. They destroyed our house and tried to dispossess the petitioner side from their land, Your Lordship. The cross affair also I have engaged as the cross affair. Both admit both sides receive injuries, and unfortunately 1 person died, Your Lordship. Incident took in the night. Page 32 is the cross affair, Your Lordship. It is lost by wife of the petitioner number 1. And civil case pending since 2021, page 28, I have annexed the documents of civil case, because we also purchased a land from the Pattada, 8 bighas of land. All are family members. The informant side also purchased 15 lessons of land, but since 2021, they are forcefully trying to dispossess us from that land. They say saying that we are purchased that land. There are dispute errors and civil cases pending. On the day of incident, Your Lordship, in the night, they came with some other person, 30, 40 people, and assaulted the petitioner side. And there is a quarrel between both sides, and unfortunately, one person died. This is the case. And
My lord, case diary received, PM report also received, my lord. From the PM report, my lord, cause of death was due to shock and hemorrhage. And my lord, total 5 injuries, my lord. Injury number 1, my lord, 1 cut lacerated injury over the left parietal and frontal bone, and 7 cm lateral to left eye, bro size 5 cm, 2 cm bone. And second injury, my lord, injury number 2, 1 cut incised wound in the skull over the occipital bone. Injury number 3, 2 cut lacerated injury on 1 8 cm and other one 10 cm from the left elbow joint were seen in the dorsal aspect of left arm. Injury number 4, a curvilinear abrasion in the left forearm below the left elbow joint. And injury number 5, multiple abrasion in the back below right scapula. Mainly, my lord, head injury is also there. So, my lord, from the statement of the witnesses, my lord, IO has collected sufficient material against the accused persons. Regarding, my lord, existence of land, for the existence of land dispute, there, how they can, my lord, on that particular day entered inside the residence of the premises of the accused informant, my lord, and against Abdul Jabbar, one Abdul Jabbar, my lord, who is petitioner in item number, my lord, 37. Against him, there is specific allegation that he assaulted over the head of the, my lord, deceased Hassan Ali. And on that day, my lord, because there are other injuries also there, and all these accused thereafter, my lord, eyewitnesses, my lord, implicated all these accused persons, my lord. Specific allegation regarding Abdul Jabbar, many 2-3 witnesses stated about Abdul Jabbar. Other witnesses also implicated the all the accused persons is, my lord, before your lordship, my lord, today 2 are, my lord, AB, item number 36 and 37, and 38 is BML. In BA, they were in jail since 16 to 26 and 22 to 20. It would be option DM. PM report is already there in the city, but this is one.
In item number 36, the petitioners already appeared, their custodial interaction may not be required. In item number 3, since they have specific allegations against the petition, accused number 1 of the FIR Abdul Jabbar, who is petitioner in 34, he may not be considered, but in item number 36, they have, since they have cooperating with the investigation, they may be considered.
The we bought put done it additional every month. The application sections CD receipt submitted by Mr. Isla that the that there was a land dispute between the parties, and on the day of incident also the informant side came to their land and tried to dispossess them from their position, and for which there was a quarrel and altercation took place between the parties, and both the parties sustained some injuries in their to that next the petitioner, wife of the petitioner number 1 also lodged an FIR, false FIR, which is accordingly registered. However, and unfortunately, one person died due to assault. One person died for the said incident, but these petitioners are not involved in the alleged offense. One civil case is also pending between the parties, and on the day of incident, the day of incident, and so day of knowledge, and the incident took place only for this land dispute when the informant side tried to evict the petitions. However, the petition number 1 is in custody since 72 days, and the other petitioners are in custody since 66 days. Hence, considering their date of detention also, they may be released. And next, Mr. Bond, could you learn it petition submitted in this regard that there are sufficient incriminating materials against all the accused petitions, and from the eyewitnesses, statement of the eyewitnesses as well as the victim, it is seen that they are all involved in the alleged offense and assaulted the victim as well as the deceased on the day of incident. Mr. Bond, according to the days of and submitted that may not be a big case unless the accused persons on bail at the stage. Mr. Paper is submitted that the PM report has already received, where from also it is seen that the injured, the victim, the deceased sustained previous injuries on different parts of his body, including the brain injury, head injury, for which he died instead. Next, hearing the submission made by the counsel petitions without going detail into the merit of the case, only considering length of detention undergone by the petitions. This court is of opinion that further custodial interrogation may not be necessary for the purpose of investigation. In view of this, the bail petition, this court is of opinion that if the petitioners are entitled for bail accordingly, all these petitions are hereby enlarged on bail for rupees. It is a case of which place?
It is Mangodar,
Huh?
CGM Dorong Mangodar.
To the satisfaction of CGM Brown. Your 38 is granted.
33. Publish.
A para of no, sorry, 36. Part Mr. 80 done it petition. And also Mr. P. Bought done it. This is an application. the accused number 4, 8, and 9. And they have not committed any such offense as a resident from the guideline. However, it is a fact that there was a quarrel between two groups due to land dispute when the informant side came to evict them from their land. The civil case is still pending between the parties, and with some false and false allegation, the FIR has been instituted against the petitioner. However, after obtaining the order of interim plea restraint, all the petitioners have appeared before the IO, cooperated in the investigation, and their statements were also acknowledged. They are still ready and willing to extend their cooperation in the further investigation if they are granted with privilege of pre-arrest. Mr. Bot, submitted আগৰ ভিতরে submission report seems the submission made by the materials available in the case diary that this court is of opinion that custodial interrogation of the present petitions may not be necessary for the interest of the investigation. In view of this, the order of interim pre-arrest plea dated 18/3/2026 is hereby made absolute with same terms and conditions. The above observation. Six. Sorry. Same technical mistake is this one same. This dispute between students in same. This 37 on submission to Mr. Sarkar seems. The water submission. Mr. Waterford submitted in this that there are sufficient materials against the present petitioner, who is stated to be the main culprit of this case, who attacked the deceased with a bamboo on his head, for which he sustained previous injuries on his head, and died out of shock and hemorrhage for such great. He further submitted that the postmortem report also reveals that the deceased died due to shock and hemorrhage for the injury sustained by him on head. He further submitted that from the statement made by the witnesses, it is seen that the petitioner is the person who attacked the deceased, his head, that is the vital part, and for which he died, instantly. Mr. Waterford accordingly raised payment objection and submitted that his custodial intervention may be required for the purpose of investigation. Next point. Hearing the submission made by non-counsel and considering the materials against them, it is seen that the present petition is the main culprit who attacked the deceased on his vital part of the body, for which he succumbed to it, and for which he died instantly out of head injuries. Considering this aspect of the case, the involvement of the present petition vis-a-vis the gravity of the offense, this court is of opinion that his custodial interrogation may be required for the purpose of investigation. The offense. Not find it efficient to extend privilege of pre-arrest bail to the present petitioner, and accordingly this same stance rejected. Okay, your 37 is rejected.
Give leave.
Bless.
Stop the
May I please your lordship? Lordship, on the last occasion, the CD was called for lordship, but
Is an interim CD is yet to receive.
interim may continue.
CD not received. Issue reminder. Yes,
On 28th May 20.
20. 28th of May, 20. Interim be continued, building step.
Deep note.
Yes, what is the position of 41? CD received here.
Lordship, may I please? Multiple decision by PAS bill application, my lord. Lordship has granted me interim protection. I am appeal before the investigating officer. I am not violating any condition, my lord, the bail order. My lord, FI is page number 18. What is happened, my lord? The informant committed fraud on me, my lord. Now he filed this FI, lordship. My lord, kindly see the FI at page number 18. FI, lord.
Yes.
May I read it?
Hmm.
সন্মান সহকাৰে আপোনালোকক এই আবেদনৰ দ্বাৰা অৱগত কৰিব বিচাৰো যে মই সীমান্ত দাস গোলাঘাট জিলাৰ গেলাচিঙা বিলখন গত 15/5/2025 তাৰিখে অসম মীন উন্নয়ন নিগম লিমিটেডৰ অধীনৰ অসম মীন মহলৰ দ্বাৰা 7 বছৰৰ বাবে নিবিদা সহকাৰে জাননী নাম্বাৰ পত্ৰন পাওঁ আৰু বিলখন মই সুন্দৰভাৱে বৰ্তমান চলাই আছো। মহোদয়, বিশেষ এই যে যোৱাকালি হঠাৎ জানিব পাৰো যে বাদুলিপাৰা ইয়ালুদ্দিন হুছেইন, দেট ইজ দ্য মাই পিটিশ্যনাৰ, নামৰ এজন লোকে মোৰ স্বাক্ষৰ জালিয়াতি কৰি মোৰ নামত মিছা তথ্যপাতি তৈয়াৰ কৰি 3 লাখ টকাত মই বিলখন উক্ত ইয়ালুদ্দিনক 7 বছৰ চলাবলৈ দিয়া বুলি অভিযোগ দেখাই মহোদয়ে আদালতত আবেদন দাখিল কৰিছে। এই আবেদনৰ দ্বাৰা মহোদয়ক জনাওঁ যে ইয়ালুদ্দিন নামৰ কোনো ব্যক্তিক মই চিনি নাপাওঁ, গতিকে টকা লৈ চুক্তি কৰাটো দূৰৈৰ কথা। অসম চৰকাৰৰ অসম মীনমহল বিভাগে মোৰ নামত পত্ৰন দিয়া বিলখন মই কাৰোবাৰ পৰা টকা লৈ চলাবলৈ মোৰ কোনো অধিকাৰ নাই। সেয়েহে মহোদয় জালিয়াতি অপৰাধ সন্দৰ্ভত অৱগত কৰি উক্ত ব্যক্তিজনৰ ওপৰত বিহিত ব্যৱস্থা গ্ৰহণ কৰিবৰ বাবে অনুৰোধ জনাই এই আবেদন দাখিল কৰিলো। My lord, what is happened, my lord? He got the settlement order in respect of my lord Gala bill mail. He supplet me, my lord. Kindly see the my lord page number 21. This is the agreement, my lord. Where is just page number 21? Page number 21, my lord. He supplet me, my lord. Sublease to run the bill, my lord. Page number 21. This is a my lord agreement. Where is my lord? He taken my lord annual rent on 3 lakhs, my lord. In page number 22 is their lodge. This is my lord agreement between the informant Simanto Das and my lord Yaluddin Hussain. Is the petitioner lodge. On 3 lakhs, he sublet me to run the bill, my lord, for 1 year. My lord, thereafter, my lord, this is the money received, my lord, at page number 24. Money received is there. Now he turned, my lord, when I go to the I went to the my lord, bill, my lord, to take the possession, my lord, there is no my lord, such bill, lordship. There is no such bill, my lord, in
No
his
bill?
No bill, my lord. He fraudly, my lord, this here. When I asked, my lord, for return the money, my lord, he, my lord, he assault me, my lord. In fact, my lord, I approached the my lord, police authority, my lord. The police authority has not taken action, my lord. In fact, my lord, there is after I filed share case, my lord, for the my lord, Lanet SDJ, my lord, Gulaghat, share case number 14/26. When my lord, police had not taking any action, my lord, I having left with no option, my lord, I filed this share case. My lord, share case is my lord, at presently pending, lordship. Now, when my lord, I asked the money, my lord, he my lord, assault me, my lord. Now, my lord, after that, my lord, he lost the FIR, my lord. This FIR, my lord. Everything is on record, lordship. Agreement is there. Money receipt is there. Now, my lord, I am running another bill, my lord, at page number 26, my lord. I am a secretary, my lord, also Nabil Puhor Undan Piti. Page number 26, my lord. He committed fraud on me, my lord. Now he filed this, my lord. Now, my lord, I give my statement.
Lordship,
Okay, I will-
as per the interim, he has appeared, my lord. Now, my lord, as per his statement, both the informant also saying that he has played fraud on me, my lord, my lord. The accused is also saying that he has played fraud on me, my lord. And now the case is that, my lord, whether the signatures in the receipts are, my lord, genuine or not, my lord. For that, my lord, on the earlier occasion, my lord, the Honorable Court, if your lordship kindly see the order of the last court regarding the interim order, my lord, it was since it was for facilitating the facilitating the accused to give the copy of the original copy of the agreement to the IO, my lord, the interim was given, and accordingly, my lord, it was the original copy was given, and the same was sent for now FSL, my lord. Now,
The original copy of the agreement was submitted before the IO.
before the IO, my lord. Now, my lord, it was sent for FSL, my lord. So now, my lord, regarding now coming to the merit of the case, my lord, regarding a money receipt that has been annexed, page 24, your lordship has seen, my lord. Your lordship, may I take to the money receipt? Page 24.
Yes.
24. My lord, here, it is said that do you hereby receive a sum of 3 lakhs rupees by the informant, my lord. And the witness that is cited, witness number 2, Upendra, my lord. He was interrogated, my lord. He also says that the signature in that money receipt is not his name. So who is telling, my lord, truth, my lord? It will come from.
Then he stood as a witness there.
No, he says that the signature is false, my lord. He did not stood as a witness, my lord.
He not stood as a witness.
Not stood as a witness, my lord.
So regarding the signature of Simanta Das,
Simanta Das, he has given the my lord, the complaint that these all signatures are false, my lord. Fraud, my lord. Signature is not his, my lord. Taking of the money, executing the agreement are all false, my lord. And the witness also, my lord, with my lord interrogated, he also said that the witness signature is also false, my lord, by the witness himself, my lord.
Well, this is my
So
lord.
it will come from the FSL, my lord, whether his signature are true or not, my lord.
whether it has already been sent for FSL.
It was sent for FSL. So perhaps, my lord, in this situation, we can wait for the FSL, my lord. Only, my lord.
This is my lord identified by my lord notary public at Gulaghar, lord.
What, my lord, I'm just.
Notary can do anything.
I'm just reading one line of the my lord Upendas, that is a my lord witness, my lord. Notary money receipt copy khonat সাক্ষী হিচাপে 2 নম্বৰ চহী থকা মোৰ নামখনৰ চহীখন মোৰ নহয়. That is specific, and at the time of investigation he has revealed. So now, my lord, this is the my lord fact of the case, my lord, and the materials against.
This is a case of 2026 first part.
2026.
You can say it can be awaited. I don't know otherwise. So seems to be what is want to say.
Yeah.
Should be awaited for the FSL.
Yes, my lord, that is the case, my lord, because if the money, my receipt is false, agreement is false, then my lord, it is then it should not be only a civil dispute. It will be something else, my lord. It will come to cheating.
No, that means your the informant Simanta Das, he is disputing all the signatures.
All his signatures, my lord.
Well, even my lord, the CR case is pending before the my lord is court, my lord, against him, my lord.
His case is that no such bill is there.
His case is that no such bill is there, my lord.
Yes, my lord.
But that
committed fraud on me, my lord.
that is not clear from
Therefore, my lord,
whether it is
and given
there
by the-
or not. That is a different thing, my lord.
Case number 26, my lord, therefore, my lord, the
But
local
you are
public.
a local person without having any bill. How can you enter into an agreement? Because
Person,
you
my lord,
have not
my
come
lord,
from
my lord,
this case is incident is of which
local,
place?
my lord.
Huh?
My lord,
That is the Dergaon.
my lord,
Dergaon. So
Gulaghat.
you are must be a resident of Dergaon, either
Local-
Dergaon, Jorhat, Gulaghat, whatever.
the
Yes.
part, my lord, which has been shown to me, my lord, he is not called under his, my lord, possession, lord.
Huh?
The part which is applied to me, my lord, he is not called under his jurisdiction, my lord. Which is which bill is, my lord, he got, my lord, as per the, my lord.
No, you are saying that no bill is existed there.
My lord, bill is there, my lord, the portion, my lord. The POCSO is not there, my lord, which is supplied to me, my lord. Therefore, my lord, page number
Yes, sir.
26.
So, my lord, this part, my lord, so I am not making any comment, my lord. He used to say, my lord, in a bill, my lord, there, if a bill crosses through the, my lord, defined districts, my lord, some portions are given a lease, my lord. To be correct, my lord, in the tender calls for, my lord, suppose there are three parts, my lord, one part is given to one part is given. He says that, my lord, a part which my lord, is supposed to be given to him, my lord, that it is not his part, my lord. This is his submission, my lord. But my
According to
lord,
my
so
petition.
far the materials concerned in the CG, my lord, stated that, my lord, the signatures are false, my lord, as per the statement of the complainant and also the witness himself, my lord. So, my lord, in waiting for the, my lord, he's on interim, my lord, it will not be any prejudice. We will
fact,
wait
my
for
lord,
the FSL for
Lordship,
one,
my lord,
my lord.
if my lord, lordship tally the my lord, page number 18 and 23, my lord, the signature is my lord, both the same, lordship.
That cannot be tallied by the court, my lord.
Or in a just my lord. Page number 18, the Simanto Das signature. Page number 23, the same signature. Okay.
So where it seems to be same, but
Lord-
how can
Lordship,
we say
Lordship,
now?
my lord.
We cannot see.
If the person who put this signature is
Lordship.
himself disputed the
Lordship,
signature.
there is there.
And
Now he can dispute my lord because there is a my lord 3 lakhs pending, lordship. He just to avoid my lord this.
okay,
Otherwise also my lord this is my lord in the nature of civil, my lord. Civil dispute.
more or less seems to be, let
No,
us
my-
wait for the next date. If doesn't come, then we'll dispose of.
Lordship.
Heard Mr. D. Gogoi, the learned counsel for the petition. Heard Mr. M. B. Goswami, the learned petition. CD received, but it is submitted by Mr. Goswami that as per order dated 20/03/2026. The petitioner appeared before the IO and also submitted the original agreement, which is stated to be executed between the informant, the present petitioner. It is further seen that the same agreement has already been sent for FSL, and the money received in that connection is also sent for FSL for examination of the the signatures, as the informant had disputed his signatures in the agreement as well as the money receipt. In view of this, let the FSL report be awaited. Yes, board.
What was sent? Let it be 18, my lord. We'll have-
No, don't give it till later.
Yes,
please,
my lord.
because it may not come also.
Okay. Whether it will send back the CD.
It has to be.
It just has to be.
It has to
Then Asugupta
Then,
Zone.
be. Maybe last part.
yes,
only.
yes,
Last
my lord.
Last
On
part only.
28, my lord.
Yes, it can.
28, 29, my lord.
28 May. CD be written, all for the updated one, along with the episode. Interim be continued till next day.
And he may cooperate if in between he is called for by the.
Interim be continued till next date of listing. Further, the petitioner is hereby asked to extend his cooperation if required during investigation. If you require, you appear before.
Lordship.
If required.
Reply, Lordship. May I please, Lordship? This is the previous bail application, Lordship.
Yes.
An interim was granted and petitioner appeared before the IO, Lordship.
You are an interim.
Yes, Lordship.
CD not received, it should remain. Yes, yes,
My lord.
Goswami.
Yes, my lord. Let it be some part of the, my lord, again, my lord. 25th, my lord.
25th of May. Interim be continued. Yes.
Much obliged. Lordship,
item number 20, in 26 and 43. These two petitions are anticipatory. I am in interim. I appeared and statement recorded. As a charge sheet has been filed, I beg to withdraw item number 25, which is BA. It has become infractious as soon as it has filed. See, charge sheet has filed. In regard to 26 and 43, as I am on interim and it is triable by sessions court, so Lordship may kindly call for the charge sheet. Otherwise, I may not appear there.
What is the CS number?
CS number, my lord, is 72/26, dated 22/4/26.
Well, same FIR.
Dated 22/4/26.
25 to heard Mr. G. Suma, the learned counsel for the petition. Also heard Mr. MP Goswami, the learned additional people bring to the opposition. Submitted by Mr.
43
Goswami,
and
the case has already been charged sheeted.
6.
By CS number 72
6.
22/0/26. Mr. Soma, the learned counsel for the petition, accordingly submitted as per instructions of his client, he wants to withdraw the same. Withdraw the present application. In view of this, and also in view of filing of the charge sheet, the charge sheet, the present therefore petitioner is allowed, and matter is accordingly disposed of on behalf. You were 26 or 43. 26 plus 43. Hired Mr. G. Sunan, the learned counsel petitioner. And also hired Mr. MP Goswami, the learned additional people, appearing on behalf of state respondent. So it is submitted by Mr. Goswami that the petitioners, the IO has already filed the charge sheet by CS number 72/2026.
No, 26 and 42.
Next paragraph, Mr. Soma, the learned counsel for the petitioner, submitted in this regard. That case is of committal in nature. Cases of session travel, and hence he prayed call for the case diary and the charge sheet with a prayer for extending his interim rearrest. Next paragraph, in view of this, let the CD along with the scan copy of the TCR be called for from the learned trial court below. Yes, Botapu, when it gets also some.
এইটো আহিব হেৰি বঙাইগাঁও অলপ 15 তাৰিখৰ পিছত
19/5, so and so. Interim be extended till next date of arrest. Okay, 19/5.
Yes, deeply obliged, my lord.
May it please your lordship.
Yes.
Non-FIR case, lordship, report was called for.
Yes, report was called for. Yes,
Lordship.
whether you have the please.
It says that no such cases are pending against the aforesaid person.
How many petitions are there?
3 plus.
Ayub Ali.
3 petitioners. Now.
Yes. Ayub
Earlier interim was given, lordship, in this.
Ali.
That will be vacated now.
Yes.
You are Mr.
That's Hussein.
Heard Mr. S. Hussain, the learned counsel for the petition. Also heard Mr. MP Goswami, the learned additional PP agreeing on behalf of the petition. The report received from the concerned police station, wherein it is stated that no case has been registered against the present petitions. Under which police station this is? Which police station?
It is regarding Bongaigaon, no?
Bongaigaon.
Jogi Gopa.
Jogi Gopa.
Police station.
Jogi Gopa.
Jogi Gopa.
Jogi Gopa.
The Jogi Gopa PS till date. Have you appeared before the IO?
No, lordship, no direction was there, lordship.
So they were not called for.
No.
You are not called for.
No, Lordship.
Next one.
There is a report that it is stated that, my lord, that they were not, against them there is no case. But with regard to another case, their interrogation is sought for. That is
Oh,
with another case. It is in PS MMR number 17/2026. This is the case.
MMR.
MMR, the missing, my lord.
Oh, MMR number?
MMR number 17/2026. I am giving the report, my lord.
That'll go to the
So-
No, last sentence to PS. You give a police station, but they are wanted for interrogation in MMR number 17 only. Let the report be kept as a part of the record. Post of further next pattern in view of in view of the no, no.
It is
as
as part
the-
of record. Lord, may I kindly- I have
it will be part of
Yes, I have.
but in view of Nalaka, as there is no case, as no case has been registered against the present petitioners in Jogikoa police station till date, the present AB intercepted bail petition is hereby disposed of accordingly, and interim granted to the present petitioner is also hereby stands vacated. It stands is not like stands vacated. However, the petitioners are at liberty to approach the appropriate forum in the event of registering any case against him. If any case is registered against him, you are at liberty to approach the appropriate forum.
Lordship.
Otherwise, at this stage, we vacated your inquiry as there is no case existed against him.
Lordship. Obliged.
Because if the record, my lord, regarding the
It will be part of the
instruction,
record. Yeah. Very good. আনন্দ। করবো তাই করে কি একটা মানে আগর পরে টাইম হয়নি কিছু Yes.
But this is an applicable passing of a complaint petition. The complaint petition is at annexure 8, page number 23.
23.
23. The matter relates to a sale purchase of goods. The relevant page is page number 23. I'm reading the relevant paras.
Yes.
That the complainant who is in the business of wholesale of medical and surgical products.
Which
What?
para you are reading? Para 4.
Para 3.
Para 3.
Para 3 in page number 25.
Yes.
Yes. The complainant who is in the business of wholesale of medical and surgical products was in need of 3-ply face masks in the course of his business in the month of February 2020. As such, after asking around in his business circle and checking online, the complainant came to know about the accused person and his firm, who allegedly runs a wholesale pharmacy which dealt in the supply of said 3-ply face masks. As such, the complainant approached the accused number 2, that is Neeraj Verma, expecting him to be a genuine businessman. After contacting the said accused person number 2, he falsely representing himself to be a genuine businessman dealing in the said 3-ply marks. Under the misconception and deceit, the complainant, accepting the accused person to be a genuine and honest businessman, had placed an order before the accused person over phone on 5/2/2020. He placed the order on 5/2/2020 to supply 2 lakh piece of 3-ply face mark at the rate of so and so, and the same was agreed by the accused. The accused person then deceitfully promised to complete the supply within 10 days and requested the complainant to send some advances. On the request of the complainant, the accused person even sent a pro forma invoice number so and so through WhatsApp against his ready stock for dispatch, stating that the goods were ready for dispatch, and the pro forma invoice was also issued, and asked and deceived the complainant to immediately make a payment of rupees 1 lakh. Further stating that as soon as the payment is made, the first batch of the goods shall be immediately sent to the complainant. Accordingly, the complainant had transferred deposited 1 lakh rupees to the complainant. Next page. But the complainant now doubts that all of this was in fact a very well planned conspiracy by the accused to loot the customer businessman into paying to him the advance amount, and after which no goods are actually sent to the customer by the accused. Now, ma'am, para 5. On the basis of assurance made by the accused person, the complainant also took order from his customers in the northeast area against 3-ply who was to be supplied by the accused person. But after receiving the advance payment of rupees 1 lakh from the customer, the accused person started ignoring the complainant and his mobile phones. Moreover, the accused person did not send a single piece of marks till date. This is their case that we have not supplied the goods. The complainant tried his level best to contact the accused and also asked around all his business circles, but the accused person could not be contacted in any manner, nor his whereabout could be found out by the complainant even after the best efforts. Finding no other alternative, finally the complainant sent his manager so and so to Jalandhar to personally go through and locally search and find the whereabout of the accused person as per the address available with the complainant, and to talk with the accused and ask him to supply the marks. The said so and so stayed there from 1/2/2020 to 22/2020. That after thorough search and inquiry, the said manager of the complainant, Mr. Ranjan Rajkua, finally found the accused person, and on confrontation and regular request of the said manager, the accused person again received the complainant and his representative stating that he should immediately send the said goods, and to further convince the complainant and his representative, the accused even handed over one tax invoice dated so and so, assuring him that the accused person will send the goods marks immediately. Moreover, to further deceive, misguide, and convince the complainant, accused person handed over one letter on his letterhead to the complainant, Abetment manager, by which the accused person assured and undertake to supply the entire 2 lakh ordered marks immediately, otherwise the compensate to the complainant adequately. But this time also the accused person deceived and cheated the complainant and did not send a single piece of marks and failed to keep his promise and assurances.
So this is their case. He did not supply the 3-ply pass.
Their case is that they have placed the order in 2020, and we have not supplied the goods. This is the plain case. Kindly peruse page number 47. This is the demand notice they have issued. Page number 47, annexure 10 inner.
Yes.
The subject is advocate notice for non-supply of marks and non-refunding of the advance money. Here their prayer is that to refund rupees 1 lakh along with interest at the rate of 18% per month plus 1 lakh, 10 lakhs as compensation for the harassment and suffered by them. So their demand is to return the amount with compensation. It is to be noted that as per their version, they placed the order on the 5/2/2020. Thereafter, they issued a notice on 28/12/2021 that you have not supplied the goods.
No, notice was issued on 28/12.
28/12/2021 that we have not supplied the goods.
Order was placed on?
Order was placed on 5/2/2020.
Yes.
Thereafter, before completion of 3 years, they filed a money suit for recovering of the amount and the present complaint petition. The money suit is at page number 60, annexure C.
Mansudat, please. Madam.
Page number 60, annexure C. They filed a suit for realization of money, declaration, damages, and compensation. There are 4 prayers. And in page number 71, the prayer is there. Realization of rupees 1 lakh in prayer 1. Second, declaration that the defendant has committed breach of contract, prayer 2. Prayer 3 is compensation of rupees 24 lakhs on odd amount. So their case is that they have placed an order and we have not supplied. Simple case. On the same day, they filed a money suit and the complaint petition in the month of February 2023, just before completion of 3 years. So my submission is that this is purely a contract of sale purchase. So it will covered by the Sales of Goods Act, not by the criminal provisions. Our contention is that we have supplied the goods to you. In my page 9, para 7, I have submitted my case. That we have sent the goods through courier, but you have not received that amount, for which auction notice was issued to us. That is annexure D, page number 75. So VRL Logistic, we have supplied the goods on 11/2/2020.
So now what is your case?
My case is that we have supplied the goods.
You have already supplied.
Supplied the goods through VRS Logistic Limited, and you have not received that amount. For that, an auction notice was issued by the transporter to us. We repeatedly requested them to collect the goods from the transporter, which is in the year 2020, 11th February. And we have filed our return statement, and the money suit is pending for cross-examination. So from the complaint petition and as well as the money suit, it can be inferred that this is purely a civil dispute regarding sale purchase of goods. They are trying to give it a color of criminal. Because initially they have said that they themselves placed order, and our contention is that we have supplied requests, we have not received them. So from the very beginning, there is no dispute. In their legal notice, they are saying that we have not received the goods, you return me the money. That is
After receiving the notice, we have supplied, or
no. We have supplied immediately on 11/2/2020.
Then why they are not receiving?
We have requested them to collect because that is a COVID period. We have requested them to collect from the transporter, but they have not received them. This is a face marks.
Yes, yes.
Face mark. So their contention is that we have not supplied. For that, they have filed a money suit for recovering recovering the amount from us, and we filed our reply in the money suit, and the suit is pending for procedure. If all the allegations in the complaint are taken, that do not primarily constitute any offense. Regarding section 406, 406, 403, 420, 503. They themselves send the money to us as per their contention. As per their contention, they have sent the amount in our bank account. And our contention is that we have supplied the goods. So it's a purely a sale purchase of goods. Their contention is we have breached the trust. We have not breached the trust. Because they gave order, we supplied the goods. Or they have availed the civil remedy by filing the money suit in the court. Only for pressurizing us to settle the matter, they have filed this criminal case. That too before completion of 3 years. 2 days before the completion of 3 years. And both the civil and criminal proceeding parallelly in the same month, on the same contention. I want to submit some package.
Yeah, no, any other submission, please. If you have any other submission, you can. Yes, these are the that you're relying.
Yes, I'm relying on
Yes.
this. Number 1, para 13.
Yes.
A breach of contract does not give rise to a criminal prosecution for cheating unless fraudulent and dishonest intention is shown right at the beginning of the transaction. Merely on the allegation of failure to keep a promise will not be enough to initiate criminal proceeding. Thereafter, the entire idea seems to be covered a civil dispute into criminal and put pressure on the appellant for return of the amount allegedly paid. The criminal courts are not meant to be used for settling scores or pressurized parties to settle civil dispute. Wherever ingredients of criminal offences are made out, criminal courts have to take cognizance. The complaint in question on the basis of which the FIR was registered was filed nearly 3 years after the last date fixed for registration of the sale deed. Allowing the proceedings to continue would be an abuse of process of the court. For continuous 3 years, they are silent. Just before 2 days, of completion of 3 years, they filed both civil and criminal case simultaneously. The next one, serial number 2, para 43. May?
Yes.
It ought to be noted that the crucial word used in section 405 IPC is dishonestly, and therefore it presupposes the existence of mens rea. In other words, mere retention of property entrusted to a person without any misappropriation cannot fall within the ambit of criminal breach of trust, unless there is some factual use by the accused in violation of law or contract coupled with dishonest intention, there is no criminal breach of trust. The second significant expression is misappropriate, which means improperly setting apart for one use and to the exclusion of the owner. Next page, ma'am, para number 48. It is equally well settled that the phrase dishonestly emphasizes a deliberate intention to cause wrongful gain and wrongful loss. And when this is coupled with cheating and delivery of property, the offense becomes punishable under Section 420 IPC. Contrarily, the mere breach of contract cannot give rise to criminal prosecution under Section 420 unless fraudulent or dishonest intention is shown right at the beginning of the transaction. My contention is that there is no such intention at the beginning of transaction. They have not shown so. It is equally important that for the purpose of holding a person guilty under Section 420, the evidence adduced must establish beyond reasonable doubt mens rea on each part. Unless the complainant showed that the accused had dishonest or fraudulent intention at the time of complainant parted with the monies, it would not amount to an offense under Section 420 IPC. It may only amount to a breach of contract at best. And the third one is para 15.
Yes.
In the case of Binod Kumar versus State of Bihar, a coordinate bench of this honorable court dealt with a criminal complaint arising out of a retention of bill amount in course of commercial transaction. This is our case. He's saying that I kept his money in my custody. The court found essential ingredients of criminal breach of trust or dishonest intention of inducements which form the foundation of a complaint were missing. The reasoning of quashing the criminal proceeding would be reviewed from paragraph 18. In the present case, looking at the allegation in the complaint on the face of it, we find that no allegations are made attracting the ingredients of Section 405 IPC. Likewise, there are no allegations as the cheating or dishonest intention of the appellant in retaining the money in order to have wrongful gain to themselves or causing wrongful loss to the complainant. Accepting the bold allegation that the appellant did not make payment to the second respondent, that the appellant utilized the amount either by themselves or for some other work, there is no iota of allegation as to the dishonest intention in misappropriation of property. To make out a case of criminal breach of trust, it is not sufficient to show that money has been retained by the appellants. Their case is we have retained the amount. It must also be shown that the appellant dishonestly disposed of the same in some way or dishonestly retained the same. The mere fact that the appellant did not pay the money to the complainant does not amount to criminal breach of trust. This is our case. Even if all the allegations in the complaint taken at the face value are true, in our view, the basic essential ingredients of dishonest misappropriation cheating are missing. Criminal proceedings are not a shortcut for other remedies. Since no case of criminal breach of trust or dishonest intention of inducement is made out, and the essential ingredient of Section 405, 420 IPC are missing, the prosecution of the appellants under Section so-and-so is liable to be quashed. Serial number 4.
Yes. 14.
14 and 18. Ma'am, if no offense is made out by a careful reading of complaint, the complaint deserves to be quashed. In my case, there no offense is made out. Their clear case is that they have placed an order for supplying goods. Our case is that we supplied the goods, we have not received the amount from the transporter. There is no criminal intention. Their case is that they supplied 1 lakh rupees to us.
What is the status of those goods? Where is lying? Is lying where? Because you have submitted that you have sent already from the
Yes.
transporters, they have not received those they supplied.
It is in the year 2021. It may be auction because we have
They have already filed an auction notice.
maybe because they have demanded money from us, and we have supplied the goods from the company in Gauhati in our name to collect them because there was a scarcity on that time. So we directly placed the order before the company and send it to Gauhati. And number 5, one more. Just. Para number 14. There was no dishonest intention or inducement on the part of the petitioner company while entering into an agreement with the complainant or opposite party, the concerning agent. The fact in totality give a complete picture of civil liability and not a criminal liability as alleged by the complainant. My contention is that this is purely a civil dispute and they invoke both the forum. For civil dispute, they invoke they file the money suit for recovering the amount. As well as they, for pressurizing me to settle the amount, they file a criminal case. Because when they send the notice for refunding the money, there is no such scenario. So my humble submission is that the complaint petition may be quashed. Yeah.
Yes.
The petitioner has conveniently showed this case as a civil case, but Lordship, such is not the situation. If your Lordship peruses, I'll not go into the facts right now because the petitioner has already gone into the facts in details, Lordship. But I'll only go to the relevant part where they have tried to mislead the Honorable Court. Lordship, I'm using the word mislead. I'll show why I'm using the word mislead, Lordship. Lordship, first of all, page number 36, the pro forma invoice, Lordship, of their own petition, Lordship. Lordship, in this, Lordship, page number 36.
Yes.
If Lordship peruses page number 36, the quantity is 20,000, Lordship, of the face mask. Lordship, then this is a pro forma invoice of amount 49,840. Lordship, on the very next page, Lordship, if your Lordship peruses page number 38, on the top, it's the WhatsApp chat, Lordship. This is when, please, we have sent the message, please confirm regarding payment of 1 lakh sent by us. They have replied, sir, received. Lordship, after that, on 6th February, we had given them the logistics phone number and date. Right side is our chat, left side is their chat, Lordship. Where is your goods? Please reply urgently. These are our messages. Lordship, on 9th February, on vernacular, we have written in vernacular language. Verma ji, kya baat hai? Aap mere phone nahi utha rahe, call karo mere ko. Lordship, that translates to that you're not picking up my call, please call me. Lordship, these are the chats given by us. Lordship, if now Lordship peruses page number 42, Lordship. 42, Lordship. Lordship, it is undisputed that we had given 1 lakh rupees. It is not even their case that we have paid them, we did not pay them the 1 lakh rupees. Now, Lordship, if your Lordship pages 11 to 20, there's one more invoice. Lordship, previously they had given a pro forma invoice. Lordship, now they have given another invoice. It is suddenly of 10,000. Lordship, suddenly from 20,000, the goods quantity, how can the goods quantity change? Lordship, while sending the goods quantity has came down to 10,000 from 20,000 and the amount has already changed to 42,000. Lordship, when they have taken 1 lakh rupees from us, Lordship, first they are sending 20,000 quantity goods, no goods were sent, Lordship. Then they are sending 10,000 quantity goods, again no goods were sent by them. Lordship, now these two by itself shows that these are fake and false invoices they have raised. Because the different amounts, both the time, different quantity of goods has been shown. They have taken 1 lakh rupees from us. After that, they completely stopped to reply to us. They completely stopped to picking our phone calls. And we have regularly by a time and again, as my senior friend has already showed the notices we have sent.
So what was the amount of 3 ply marks used to be sent to you?
It was 1 lakh mask, Lordship, 1 lakh mask. And that too.
Money you have paid is rupees 1 lakh.
We have paid 1 lakh
rupees. The amount of marks is also 1 lakh. You are supposed to purchase or you are supposed to supply with 1 lakh marks or how many marks?
Lordship, 1 lakh marks. 1 lakh was the advance, after which the full amount was supposed to be paid. That was
1 lakh was the advance amount you have paid, and
Lordship,
he is supposed to supply you 1 lakh.
1 lakh marks, Lordship.
1 lakh.
Lordship, the biggest, Lordship, why I use the word misleading this honorable court, by now, Lordship, again and again, they are saying we had sent the mask. And Lordship, which is a very serious allegation I am putting, Lordship, page number 75. And conveniently, by showing this document, Lordship, they have taken the interim protection from this honorable court and state the matter. If your Lordship page number 75, annexure number D. Lordship, if your Lordship sees consigner, Shanti Engineering. Lordship, who is Shanti Engineering? No one. I am Kamal Sethi, and my proprietorship firm is Mahavi Pharma and Surgicals, Lordship. Shanti Engineering is no one. There is a third party, and that is the consigner. And the Lordship, the consignee is Royal International, and that is the petitioner's firm, Royal International. Some random consignment note they have bought before this honorable court, and they are actually making this statement that they have already supplied us to the goods based on this consignment note. Lordship, clearly written their own document. Lordship, is this not misleading the honorable court? The consigner is Shanti Engineering and the consigner is Royal International. And Lordship also the declared value of goods. Lordship, very important to peruse. 21,840. We have paid 1 lakh rupees. They have raised the invoice of 46,000 and they are sending declared value for 21,000. This is some document they have bought. We are nowhere related to this document. And they are saying that based on this document, we have given you the goods. They have not only cheated us, Lordship, they are cheating the court, honorable court also by giving this document just to take the interim protection from this honorable court, Lordship. Lordship, also based on this document, they have made the statement they have made in the petition, page number 9, paragraph number 7, Lordship. If I may read out the statement they have made. The level of, the extent they have gone, Lordship. If I may, Lordship.
Yes.
Lordship, the petitioner further states that based on the
Page number
preliminary
9. Para 9.
Lordship, page number 9 of the petition, paragraph number 7.
Yes.
Lordship, yeah. It is 1, 2, 3, 5, fifth line, Lordship. The petitioner further states that based upon the preliminary discussion, the petitioner had sent stock of 10,000 masks to the respondent at Gauhati against invoice number. Invoice number, this one is for 46,000, Lordship, may be recorded. And then through VRL Logistics Limited, which was booked on this date from Vadodara to Gauhati by the consigner. Lordship, Shanti Engineering. Who is Shanti Engineering, Lordship? No one is Shanti Engineering, Lordship. To the consignee Royal International. Royal International is the petitioner. And then they are writing the statement, but the respondent did not claim the delivery of the consignment. Lordship, why will the respondent claim delivery of some other consignment which was sent to some other person, Lordship? Lordship, how can I claim delivery of these goods, Lordship? And based on this, they are saying that they have supplied me the goods, Lordship. And Lordship, the real facts are also rise. I have sent them again and again. I have sent them legal notice, which is an admitted fact, which is an admitted fact as admitted by the petitioner, Lordship. Even after receiving those notices, Lordship, they ought to have replied me, I have sent you the goods. Not once they picked up my call, not once they have replied to the notices. Lordship, that's why I'm saying that they have cheated me, because they, not only with me, Lordship, from my business circles, I've got to know that they are doing this during that Corona period when mask was life-saving good, Lordship. At that time, there was huge scarcity of the mask. At that time, what they are taking, they are taking orders from everyone. They have taken orders for crores of rupees, and they do not have any mask to supply, Lordship, at that period. In that period, they are doing all these acts. And they're sending some random invoice, they're sending some consignment note to us, and they have taken the advance amount, and they have never returned the advance amount, Lordship. So that is the thing. And with regards to the civil case, again and again, they're stating, Lordship, we were bound to do this civil case because 3 years limitation was there. Now we'll get on that is a completely different issue. There is no bar to file a civil case when we have already filed a criminal case. Lordship, with this, in this respect, I am submitting 2 judgments, Lordship, of the Honorable Supreme Court, both of them. Lordship, page number 2, paragraph number 4 of the Kamal Shivaji Pokarnikar judgment. Lordship. Lordship, paragraph number 4, Lordship, if I may read out. Yes. It is settled law that the magistrate, at the stage of taking cognizance and summoning, it is required to apply his judicial mind only with the view of taking cognizance of the offense, or in other words, to find out whether a prima facie case has been made out for summoning the accused persons. The learned magistrate is not required to evaluate the merits of the materials or evidence in support of the complaint, because the magistrate must not undertake the exercise to find out whether the materials would lead to conviction or not. Lordship, in this case, the magistrate has rightly taken the cognizance of the case. Lordship, now also one more thing, paragraph 5, quashing the criminal proceedings is only called for in case where the complaint does not disclose any offense or is frivolous, vexatious or oppressive, Lordship. We have clearly, I will again show, Lordship, in our complaint, we have clearly established how the case has been, the criminal case has been disclosed, clearly disclosed. Lordship, now next page, Lordship, paragraph number 9. Having heard the learned senior counsel and examined the matter on record, we are of the considered view that the High Court ought not have set aside the order passed by the trial court issuing summons to the respondents. A perusal of the complaint discloses that prima facie offences are alleged against the respondents. The correctness or otherwise of the said allegations has to be decided only in trial. At the initial stage of issuance of process, it is not open to the courts to stifle with the proceedings by entering into the merits of the contentions made on behalf of the accused. Criminal complaints cannot be quashed. Very important, Lordship. Criminal complaints cannot be quashed only on the ground that the allegations made therein appear to be of civil nature. What is important is that if the ingredients of the offence alleged against the accused are prima facie made out in the complaint, the criminal proceedings shall not be interdicted. So, if just because it is of civil nature, or if you have filed a civil case, that's no bar to file a criminal case. What is important is that in the criminal proceedings or in the complaint, the necessary material offence must be made out, Lordship, which has been made out in a complaint. And Lordship, the other judgment, Indian Oil Corporation, Lordship, only one paragraph. I will not take too much time of this honorable court. Flag mark, Lordship, the flag mark page. This paragraph number 9. Subparagraph number 5, Lordship. I'll directly go to the paragraph number 5, Lordship. If I may, Lordship.
Yes.
A given set of facts may make out the pure, Lordship. These are the principles the Honorable Supreme Court had discussed on more than many judgments, more than 5 to 10 judgments. And then they have laid out the principles. The principles are as follows. The fifth one is a given set of facts may make out purely a civil wrong, or B, purely a criminal offense, or C, a civil wrong as well as criminal offense, like in our case, Lordship. A commercial transaction or a contractual dispute, apart from furnishing a cause of action for seeking remedy in civil law, may also constitute a civil or criminal offense, Lordship. As the nature of the scope of civil proceedings are different from criminal proceedings, the mere fact that the complaint relates to a commercial transaction or breach of contract, like pointed out by my learned friend petitioner from the for which a civil remedy is available or has been availed, is not by itself a ground to quash criminal proceedings. The test is whether the allegations in the complaint disclose a criminal offense or not. That is, Lordship. Lordship, if just one paragraph I'll point out from the complaint case just to show that I have already alleged in my complaint. Lordship, page number 32 of the petition. The averments that we have made out. That is their annexure, Lordship.
Yes.
This is part of the complaint petition filed in the trial court. Paragraph number 12, Lordship. That from the above facts and circumstances, it is clear that the accused person has committed fraud, cheated the complainant by representing himself to be a genuine businessman, and then deceiving the complainant into paying the advance amount in the guise of supplying the said goods. The accused even issued false and fake invoices. I've clearly laid out in the complaint that those invoices are false and fake, showing that he is going to deliver the goods. Because a invoice, that's a GST invoice, that cannot be taken very lightly, Lordship, because GST invoice once raised, they have to send the goods, Lordship. The accused has dishonestly misappropriated the money. That money was after repeated notices. Our money was never returned back to us, neither any goods was sent. As we have shown that the consignment note they have enclosed, that is on the face of it, it is false, Lordship. The accused has dishonestly misappropriated the money and criminally and dishonestly breached the trust of the complainant and cheated the complainant, as he has never supplied any goods and is now not contacting the complainant in any manner and evading him. From this paragraph itself, Lordship, the whole complaint, lots of allegations have been raised, but from this paragraph, the whole conclusion is there, Lordship. So, that is my main case, Lordship. All three allegations are there. They have deceived me, they have induced me to pay, they have done dishonest acts, then they have misappropriated my property, my 1 lakh rupees they have misappropriated, they have broken my trust, Lordship. All the allegations we have raised. That is the case. And mainly our case is fully, their whole case is based on that annexure number D, that consignment note, Lordship. That is from the face of it, if your Lordship, it is clearly a false, Lordship, which is a very, I think, which is a very serious allegation that we are raising right now. Let maybe send for trial. The trial court will definitely give them a chance to decide all the points, and they may give the defenses also possible. Obliged, Lordship.
Regarding the annexure D, I've already stated in my pleadings that we have sent some part of the materials through Santi Engineering to the consignor in Gauhati.
Now, who is Santi Engineering?
Is the manufacturer of face marks from Gujarat.
Consignee is also Royal International Lordship.
Because
They are
at-
themselves Royal
Because
International.
at that time, the face mark is on very high demand. We ordered them, they said that you send the face marks. Accordingly, we have ordered in the factory, and the factory has directly sent in our name to Gauhati. Because in the auction notice, the booking date is 11/2/2020, and the station is Gauhati. They said that you send, we will receive that amount. This is one part. Their contention is we have not supplied. Our contention is that we have already supplied, and that is pending in the civil court whether we have supplied or not. My contention is not that we have supplied or not. They themselves, their stand is that they have paid the amount. We have not induced them to pay the amount. They have placed the order before us to send the goods. Accordingly, we have supplied the goods. And now they are saying that we are inducing them to pay the amount. Because in the complaint petition, they themselves said that we searched some vendors. Accordingly, they placed order on 5/2/2020, and they placed order. Accordingly, we have supplied the goods. So whether we have supplied or not, that is a question of time. That I will prove.
Definitely.
But their contention is they themselves paid the amount to us.
Oh, yes.
We are admitting we have paid the
We
amount.
have paid the
They have.
amount. No dispute.
So there is no criminal there. They filed a suit that we have not supplied the goods. For that, they have filed a money suit. From the very beginning, they are saying that our intention is wrong. There is no such thing. Because, and 406 and 420 cannot go together.
It is what is the stage of the case at present? Only cognizance has been taken.
Only cognizance has been taken.
Charge is not yet.
With regards
So
that is,
this is a pressure tactics. Otherwise, for every money suit, there will be a criminal prosecution on the same day. In one side, they will file a money suit. In the same day, they will file a criminal case that he has not paid the amount. He has not returned the amount. Only for pressurizing us. There are no ingredient of 406, 420 is there.
our case is not about the money. One last line just. Our case is not about the money, Lordship. Our case is about the false pro forma invoice, false of a different amount, and a false invoice of a different amount, and then the false consignment note. That is
No,
it.
no. This is not
And
the case.
through that, they have induced us to pay the 1 lakh rupees.
This is not.
And never send any goods, nor return them.
No such declaration is made in the money suit that the invoice is false. No such declaration.
Order repeated.
All right.
Other matters, please.
There is an interim order in 13 and
30
13 and 14. Interim order is there.
and 40. Okay, we'll extend your interest. Rest will be the 30. 25th of
My lord, item number
Okay,
52
item
is
number 52.